Yes. Thursday. What? Why dispose of matter again? What is it not based on court's time? No, is it not based on court's time? You will make the court to hear the matter, dispose of the matter, spend an hour time. Now you say that you recall that order, and how can you file it for being spoken to for that? I'm not requesting an order that is passed, a matter that is disposed of in a for being spoken to. How can that order be recalled and sent to the Lok Adalat? Come up with an appropriate application. Yes.
This now was released order for payment of maintenance in one stretch. Yes, the order was passed on 17th. Able to in one stretch. So I'm seeking.
We'll come up on Monday. Yes, lizard matter on Monday. Yes.
Your Lordships kindly. List number 2, serial number 4,
No,
Your Lordship.
out of the list mentions, list wise they will call.
Yes.
Yes.
No, we are not hearing court officers' voicemail.
I think it is muted.
Page 5, serial number 16 to 18.
Now are you able to hear?
My lord,
Yes.
my lord, serial number 18, my lord.
Yes.
My name may be deleted and HS Lingraj name may be shown. He has filed wakalat.
Where
18,
is
serial
your
number
name?
18.
For respondent number. Or
2. R1.
Lingaraj, Spurti Hegde, Nagaraj. No. Where is his name? Vijay Kumar's name here.
for R1 in the 18, serial number 18 for
18.
first matter.
It will be deleted. What is the difficulty for that to mention and asking for it? We'll see.
No.
Somebody else has already filed wakalat.
HS Lingraj already
No,
filed.
yes, filed wakalat. At the time of hearing, we'll do that. It's not a big issue to be done now. Yes.
Please, ma'am.
Page number 6, serial number 19, 20. Page number 7, 21 to 24.
My lord, serial number 20, 24, my lord.
Yes.
My lord, this matter is connected with another matter 8083/23 and it is pending before the division bench, my lord.
So this also has to go.
Yes.
And council submits that. The connected matter. So and so, what's the number?
8083/23.
8083 of
23.
23 is pending before the division bench. The list is matter along with so and so before the division bench after obtaining necessary orders from the Honorable Chief Justice. Yes.
Page number 8, serial number
Yes. Huh?
23.
This is 2023 matter. Will you issue notice in this? We'll see when the matter comes. Why to in filing recall application? For that you want adjournment. This is matter. on October 15th. Yes.
Serial number 30 minutes. Petitioner
30?
30.
Page number,
Page
page
number
number 8, serial number 25 to 30.
For the petitioner minutes, adjournment, we have applied for a certified copies. So till
2024 matter. So far, notice is also not ordered.
1 week time.
We will see. Yes, next.
Serial number 28, my lord.
20?
28.
Hmm.
I'm for respondent in this case, my
Happy
lord.
for the petitioner.
During the overnight stay with the children, my lord, yesterday some developments have been done, Your Honor. Kindly may I have it tomorrow by 5 o'clock in the chamber, my lord.
Please, my lord,
What are those developments? Why you should be taken up for in the chamber?
Because yesterday younger son was cried a lot to stay with the mother, my lord. Kindly may I have it,
What
another
was the order in
interaction.
this?
My lords, interim order has been given, my lords. Saturday, 3 p.m., children has to be given to mother. And then the next day, Sunday at 11, they can be taken.
Elder
So
son,
the order was given.
elder son was there, my lord. Only the thing is, younger one cried a lot. Thereafter, the
Oh, that's the matter the other day in the chamber. So what happened, Engerson?
elder son was stayed with the mother. Younger one cried a lot. Thereafter, they came back to father house. That is why tomorrow may be posted for.
So why in the chambers? You can submit what it is today. No chamber in that. For that, you can tell the court what is transpired on that day. We'll hear the matter next.
Page number 9, serial number 31 to 37.
Serial number 31, my lordship.
Hmm.
We are for petitioners.
Yes.
We will inform other side, my lordship. Kindly, first time
There
1
should
week,
be
my
reason
lordship.
for adjournment. That 24
We are
matter.
not feeling well, my lordship. Kindly, post it for 1 week.
Any interim order?
Interim order, no.
Not there. Then we will give it in October. List this matter on 15th of October.
Page number 10, serial number 38 to 42. Page number 11.
My lords, serial number 41, my lords. My lords, for the respondent in this matter, my lords, we are requesting to adjourn the matter because we have to produce some documents in this matter, my lords.
Who appears to the petitioner?
S.V.
My lords,
Prakash.
we have informed other side, my lords.
They have no objection.
No, my lords, we have informed.
And counsel for the respondent seeks time and submitted that it's already informed to the counsel for the petitioner. List this matter on 18th of September.
Grateful, my
Serial
lords.
number 47, respondent
40?
7.
To page number
Respondent.
11, serial number 43
I'm appearing
to
for
61.
petitioner.
1 week time. 1 week time.
Why?
Senior not well. Senior not well.
What happened? This matter has come up on the last occasion also.
I'm appearing for petition in this
What
case.
happened last occasion?
They thought that they'll be engaging another counsel, your lord, my lord.
How can the matters be adjourned like this? If you're not asked for a week, in this place, some other matter would have come. People who are interested and waiting for the orders, they would have argued. Please understand, I request advocates not to make any, just like that, don't ask for casual. At the request of learned counsel, the respondent, finally a week's time is granted, no further adjournments, and they shall not make any mention for this matter at the time of, in the morning. Yes,
Page
Serial
number
number 50, my lord.
Huh?
Serial number 50.
yes.
Senior mother not feeling well, my lord. 1 week, my lord.
Already 4 adjournment taken,
We will
madam.
see then. We will see.
Alias balance of 1
We
lakh.
will see.
serial number, page
42,
number,
my lords, 42. My lords, it's a mediation on 16/8, my lords. They're going to settle.
16/8.
Please, my lords.
No, 42.
Please, my lords.
Then council submits the mediation is on 16/8. Plus this matter after the report is received from the mediation center.
Please.
Yes.
serial number, page number 12, serial number 52 to 56.
Serial number 53, my lord.
53.
I appeal for the petitioner. Senior is not keeping well, my lord.
Huh?
Senior is not keeping well. So kindly have it after September 5, man.
September 5th.
Yes, ma'am.
You have an interim order in this.
No. We don't have yes, my lord.
Have you
And
informed the
yes,
other side?
I have informed the other side advocate.
At the request of learned counsel, the petitioner, it is submitted that there is no interim order granted in this, and it is already informed to the other side.
Yes.
List this matter on October 8th.
Great.
Serial number 55, my lord. I'm for the petitioner.
Serial number?
55, my lord. I'm for the petitioner. Only 2 days time I have got. Senior is not staying.
Inform the other side.
Yes, my colleague.
Same, it is informed, it is submitted.
Interim order, wait.
At the request of learned counsel, the petitioner, this matter on 2nd of September, it is submitted that already the same is informed to the counsel for the respondent.
Page
Intermod
number,
alia granted. In all these adjournments, wherever there are intermod, whether they ask or not, it's done. Yes.
page number 13, serial number 57 to 61.
57, Your Lordship, I have it on
First
Thursday, my Lord. Thursday
Why?
or Monday. My Lord, my colleague is
I am for
admitted in
respondent.
nursing home, therefore I have to go.
My submission, they've taken lot of adjournments.
Huh?
I am for respondent in this case, Lord. They have taken
Your
lot
Lordship.
of adjournment, my Lord. So my submission is in matter of 2011, Lord, MFM, Lord, earlier they filed MFM, Lord. This summer court has amended matter back to the trial court, examine the doctrine, Lord.
My Lord, I would have done it,
Document, Lord,
but for the
tribunal has
fact
awarded,
that
my Lord.
my colleague is admitted in nursing home, I have to go.
Then
Then counsel for the
Your Lordship,
appellant,
take it on Thursday, my Lord.
counsel for the appellant seeks time,
Next
then
week.
counsel for the respondent opposes the same, submitting that this matter is adjourned on several occasions at the request of the insurance company, and accordingly you moved the memo.
Yes, I moved.
Accordingly, as such, the respondent claimant has moved the memo. Finally, list this matter on Wednesday. No further time will be granted.
Yes, ma'am. Right, just.
Yes.
My Lord, seal number 60, my lords. I
Yes.
appear for the respondent number 2 in this case, my lord.
Huh.
A week's time may be granted, my lord. I will inform the appellant counsel in this case. I appear for the respondent number 2 in this case.
Who moved the memo?
The appellant has moved the memo. I will inform the appellant
Serial
counsel.
number,
Appellant will move the memo.
Yes,
You will tell the appellant that you will take time
My
and
lord,
he agrees
for
for it.
some reason, we are not able to trace the file, my lords. Kindly, my lords. Serial number 60. 60.
You know, when your appellant has accepted for this, list this matter on
21.
17th of October.
21, 22nd.
No. Matters, once you seek adjournment, now that's for the court to give the date. Yes.
serial number, page number 14, serial number 62 to 64.
Yes.
List number 2, page number 1, serial number 1 to 3.
Serial number 3, my lord.
Serial number 3, for the appellant.
Mm.
Already they have appeared through the advocate, my lord. It is come for dismissal.
Who appeared?
Second list, second.
Second list.
Yes.
Second list, sir.
My lord, in that manner, I am
Matter
for-
is dismissal.
serial number 3, my lord.
Uh,
I am for the appellant. My lord, Lakshmi kindly have it on Wednesday, my lord. I informed them, my lord, the opposite. Wednesday, day after.
Wednesday,
Please.
at the request of learned counsel, the respondent.
Page number 2,
Serial
number 4 and 5.
Serial number 4, Your Lordship. Serial number 4 may be referred to Lok Adalat, Your Lordship.
It is submitted that the matter may be referred to the local.
4-1, they have filed an application for restoration, Your Lordship. It may be allowed subject
And
to
for the
denial of
petition.
interest. The same may
Everything
kindly-
can be done now itself. Everything can be done at the time of mentioning. You have to wait for it.
Yes, yes.
Yes.
Serial number 5, my lord. Wait for time, my lord. Take instructions from the.
Yes, 5. At the request of learned counsel, the petitioner list the matter on 8th of October. Why not, why, if not today, why you should be?
Instructions from the client.
Regarding what?
Regarding my lord, she was aged about 59, my lord, at the time of accident. And also, I need to file some translation of the document. Next week, I need to.
Now it has become a big ground for adjournment, translation, FIR translation.
We have received LCR.
This is a matter on 22nd. This, where is their PS? The PS has not come. No, their the court officer. At least somebody should say what are the dates they want. As per their convenience, we'll give the dates. Yes, next. Call the list.
List number 1, for dismissal, serial number 1.
Appearing
Court
as
to
the
begin.
petitioner, you are. We have. So Swapna Dayan. Swapna Dayan. No, serial number 1.
Serial number 1.
Ah, it's Swapna Dayan.
Rohit Kumar versus Jyoti.
Prabhu Gowda.
Yes, ma'am.
For petitioner in this case, my lord. It may be referred for the mediation, my lord. My party is intending to go for mediation.
May I make it one mention? In the meantime, shockingly, I have received a message stating that the respondent has been murdered. I have to bring the LRs on record.
What is this matter about?
Father is alive, so I'll have to bring.
No, what is the impugned order?
Impugned order is for payment of maintenance, that's all. So
Maintenance to the child.
maintenance to the wife.
Husband is
Now
no more.
in husband is the petitioner.
Wife is no more.
Wife is no more. She has been murdered. Now, even if this court orders that, she will not be in a position to receive because she is no more. And unless some LRs come on record, the order becomes infructuous.
You have to do it in the trial court now.
True, madam, true. But then the order becomes infructuous even if your lordship orders so, because the recipient would not be aware.
It is by the, then what compromise you are talking about?
Actually, this is actually a counsel on record requested me to pray for this one, mediation. I'll just discuss with him.
She is not alive.
With whom?
As I told you, she has been murdered.
Ask him to come tomorrow.
Yeah, please. Obliged.
Delete from the caption dismissal tomorrow.
Serial number 2.
Appearing, we have the petitioner, Your Honor. We have filed this.
Sebastian.
Yes.
Appearing for the petitioner, Your Honor. We have filed this petition for speedy disposal, Your Honor.
Where is that?
Page number 3. Relief prayed us for the speedy disposal.
Of which case? Where?
On MC number 1816 of 2019, before the second additional family court, Your Honor.
Please come.
Your Honor, this petition was filed on 28th.
The petition is filed seeking the following prayer. The land council appearing for the petitioner submits the MCs of the year 2019, and there shall be a direction to the family court to dispose of the matters. Already directions were issued to the family court Bangalore to dispose of the matters till 2019. In that view of the matter, the petition is disposed of, directing the second additional principal judge family court Bangalore to dispose of MC number 1816 of 2019 by December 15th.
Much obliged, Judge.
Serial number 3.
Accordingly disposed of. Yes, next.
Petitioner, my lord.
Samir Resent.
Matter, my lord, office objection may be overruled as they have appeared before this honorable court and
Last time it's
The respondent is already served. List this matter along with so and so. Yes.
Lord, here the case is that, my lord, we have sought for the.
Yours is 20111.
Yes, my lord. Petitioner.
You appear for the husband.
Yes, my lord. Before the trial court, I am the respondent. There is a divorce case filed by the.
What is the maintenance granted?
Maintenance not yet granted. Here the case
Visitation.
is still pending, and we have challenged the order of custody. We have sought the child custody, and that is the rejected.
Where is the impugned order?
My lord, page number 15 may kindly be pushed. 23 is the operation portion. Page 23, in page 23. IA number 3 filed
The
by
respondent is hereby granted right of visitation to visit his minor son on every second and fourth Saturdays and the following Sundays of each calendar month between 10 a.m. to 6 p.m. with prior intimation to at the same time. Permit the applicant to make phone call to the children during holidays. What is that you sought for?
My lord, custody of the child. On the ground that, my lord, on 30th 7 2019 she left to the her parents' house and where the child was born. And there a child was born at the Mysore where her mother's house. And she left the matrimonial house on 31 7 2019. Thereafterwards, she did not return to the.
So, to whom the visitation is granted? To the mother.
Father.
My lord, this is.
Respondent.
My lord, this
We are seeking the custody of the child, interim custody
this
of
is
the
a
child.
divorce petition filed by the wife, my
It
lord.
appear in 20111 or 19357.
2031 for the petitioner, my lord. Petitioner-
Husband's
respondent.
petition, my lord.
Yes, my lord.
My lord,
Asking. Yes.
My lord, I am agreed with the order on the ground that, my lord, here the honorable trial court at para number 12.
What you sought for? Custody court will not give at the time of as a interim application.
Yes, my lord. This
Court
would
will
have-
consider the visitation. Court had granted the visitation. So custody can't be granted. Visitation, what else you want? That's how simple.
Petition is concerned, my lord. My mother is also want to see the child. Mother, grandmother, that is the mother of this respondent. And here the petitioner before the trial court is pursuing her studies, and she is also searching for the job, and she is not having the sufficient time to take care of the child. Under these circumstances, I may be permitted to have the access of the child for once a week, my lord. That is what my prayer before this honorable court.
Now, please tell the court when what is the date of birth of the child?
Date of birth.
my lord, 1
Born
2020, my lord.
9/3/2020.
9/3.
93.
2020.
From when the parents are living separate?
From the very beginning, my lord.
Huh?
Before birth, my lord.
Right. At the time of pregnancy, she went to the
Mother's place.
mother's home, and there were differences between them at that point of time also. Subsequently, they stayed separately. Now, she has filed a petition for divorce,
Which year is that?
my lord, in
2024
2024.
is, then GNWC.
GNWC is not filed. They have filed an application in the MC petition itself, in the divorce petition itself.
No GNWC.
No
till now,
GNWC is filed.
They have never visited the child.
No, never.
Right from 2020 till
No,
now.
no. He used to come very occasionally, and when he comes, he used to come drunk. That is the problem. So, there was a serious misunderstanding between the husband and wife on many issues. In fact, he is not a person who goes and earns. He doesn't earn at all. He spends, he wastes his time, and he will be always on his mobile. Even when he occasionally visited the child, he never used to interact with the child, and he used to be on his mobile seeing YouTube videos. So that is his habit. Only thing is, he has taken it as a challenge because she has filed a petition for divorce. He has taken it as a challenge to claim the ward.
Where is the mother staying? No, which place?
In Mysore.
Both of them are in Mysore.
No, husband is in Bangalore.
Bangalore. How will you see the child every week?
Where is the page number 31, my lord?
No, how will you see the child every week?
By traveling.
You will go there.
Yes. Here my case, my lord. Para number 12 of petition, MC petition may kindly be page number 31, my lord. Here, until 10th, 4th April 2024, I keep on visiting the wife and also child. Here, my learned friend is submitting that.
I will not go into that. So every week you want to go and visit. What is the age of the child now? 5 years.
5 years.
So what is the difficulty of the mother?
My difficulty is, my lord, now the child is going to karate classes and also skating classes, my lord, on Saturdays and Sundays. So that is the difficulty that she is facing. And every time he comes, my lord, he comes home drunk.
Fortunately, no, that we will address. But you cannot say because the child has to go to karate class, go to some other skating class. So meeting the father is not important.
That is important, my lord. That is important.
Then that case, so that aspect we'll forget about. 5 years child.
Yes, 5 years child.
Forget about that. So what is the next? Well, what is the evidence to show that every time he's coming drunken?
My lord, there is no such evidence, my lord.
You will tell him, if you have anything of that nature, please come to the court and tell the court. Basing on that, we will review the order.
Yes, my lord.
That is one thing. Second, no, he stays in Bangalore. He is making all the efforts to come to Mysore and see the child. Mother should not have any objection for that.
He used to come. Even before this order also, he used to come. But occasionally he used to come, and whenever he came to meet the
then
child.
That's not your problem. He is coming all the way to Bangalore. I mean,
From
to
Bangalore to Mysore, yes.
to Mysore.
Yes, sir.
And whatever he is doing. So what is that? What is your problem? He is not harming the child.
Except, my lord, the harm is, my lord,
What
the
we do
influence of the father will be there on the child, my
What we do
lord.
is, we will, whatever is the time, we'll try to see that he has time for himself as well as to the child has his own time.
Yes.
So instead of having that Saturdays, Sundays, everything, because he wants to go every week, we'll restrict it to 1 day every week.
Yes, ma'am.
No,
So Sunday, Saturday, now if you look at the order, order says -1 on every second and fourth Saturdays on the following Sundays of each calendar month.
Yes.
So he's having 4 days.
4 days in a month.
In a month. Now what we do is instead of Saturday and Sunday, we'll say every week, some time we will grant only 1 day.
Yes.
So that whatever if the boy is having Saturday, any other classes he can have.
Yes.
Sunday, let him meet the father.
Yes, my lord. Then I'll have to discuss with my.
No, whether you're
only
whether
to the point, my lord.
Not it's going to
No, only to the point as to when the classes are there. I'll just have to get the information.
Get the instructions.
My lord, kindly have this one tomorrow, my lord.
The problem
The
is
problem is my
court as well has the problem. The list,
Yes, yes.
every day 70, 80 matters are there. With all rehearing the matters and all, unnecessarily court's time is wasted. One phone call you can get. If it is Saturday, or you can I'll pass the order, You can
Yes.
inform the court officer by evening. If that is required Saturday or Sunday, we will change.
Yes,
Please come. The agreed with the order passed in I number 4 in MC number 793 of 2024 dated 3rd June 2025, whereby the father is granted the visitation rights of the minor son on every second and fourth Saturdays and the following Sundays of each calendar month between 10 a.m. to 6 p.m. Both the mother and father are before this court. The mother's writ petition is MFA WP 1957 of 2025, and the father's writ petition is 20111 of 2025. Then counsel appearing for the father, father submits that mother is working and she has no time and the time to take care of the child, and whereas the grandmother is ready to take care of the child. As such, the court ought to have shifted the custody, or at least every week we should have been given the custody of the child. It is submitted that granting visitation on second and fourth Saturday and following Sundays is not just and reasonable. When counsel appearing for the respondent mother submits that mother is agreed with such order because on Saturdays and Sundays, boys on the weekends, boy is having extracurricular activities. Because of the visitation, the father is not, the child is not in a position to go for the classes. And apart from that, it is a submission of the mother, it is a counsel for the mother that the father comes to the visitation in a drunken state, and all the time he is on his mobile, absolutely no attention to the child. It is submitted that only as a counterblast to the MC that's filed with the wife, the husband has come up with this application. It is submitted that if he has an intention to have the visitation, have the custody of the child, he would have filed a petition under the Guardianship and Wards Act seeking the custody of the child. It is submitted that the order requires to be, the order impugned needs to be set aside. Next paragraph. Having heard the counsels on either side, there is a material on record. The first submission of the learned counsel appearing for the father that the custody has to be given to the father has no legs to stand. In an MC filed by the father, the court will not grant the custody of the child to the father on the first count. Secondly, even in that case also, as an interim measure, court will not grant the custody of the child, and he is only entitled for visitation. In this, as argued by the learned counsel, there is mother, the father has not filed any application seeking custody, and this is first time in an MC filed by the wife, he has filed an IA seeking visitation rights. Then coming to the submission of the learned counsel for the mother, that the boy has the classes, as such he cannot meet the father. That submission also cannot be appreciated as for the overall development of the child. Apart from the activities, what is more important is the love and affection of both the parents. And either of the parent has no right to deprive the child of that, or deprive the child of that. Then coming to the order of the court, then the other submission with regard to the father, that the father is coming to meet the child in a drunken condition. If the same is brought to the notice of the court, with sufficient material, the order will be reviewed. The order has to be reviewed, and the any modification in this regard is required, it is always open to the mother to bring all these things to the notice of the court, as the welfare of the child is a paramount consideration for the courts. Then coming to the order, the court had granted second and fourth Saturday and Sunday. Completely granting the visitation on Saturday and Sunday, the child will not be able to spend any his time, at least a day in the week. And continuously making him sit with the father for 2 days is also difficult. And as submitted, he is having extracurricular activities. So the court has to balance both the aspects. In that view of the matter, this court is passing the following order. Number one, the order impugned is modified, and the father can exercise the visitation on every Sunday between 10 a.m. to 6 p.m. Next, number two, the father shall take all steps to see that the visitation runs smoothly, and he should spend qualitative time with the child. Number three, if the father comes to the visitation in an drunken condition, the mother, with the necessary material, can file an appropriate application before the family court, and family court shall consider the same and pass appropriate orders. Accordingly, the family court's order is modified as above disposed of. You can tell by the end of the day
Whether it is Saturday or Sunday.
You can tell the court officer.
Yes, ma'am.
And inform him also
Yes, ma'am.
for the matter. Yes, next. In 3.1, Mr. H. Manjunath submits that he has instructions to appear.
Child number 4. Child number 4.
Notice to R1 returned
For
as
the appeal,
as per the postal shira, returned as unclaimed, amounts to deemed service of notice. Then who are R2? Who is R2?
R2 is insurance company.
Which company?
HDFC.
HDFC. Where are the list of the advocates? Mr. Ravi S. Sampati is directed to take notice on behalf of the respondent, second respondent insurance company, and the land council shall serve the copy of the appeal memo on the council. Then what else? Delay is there. Note on that also notice. Yes. This is matter on 16th of September. By the time insurance company shall file their objections, if any, to IA number 1 of 23. Please. Print the name of Mr. Ravi S. Sampati. Yes.
Child number 5. Adi Narayanappa.
This case,
CR Ravi Shankar.
what is to the first respondent kindly dispense it, because the R1 is ex parte in the trial court.
Give a memo.
They are not furnished.
Give a memo.
Copies are not furnished to me.
Huh?
Copies. I have to
No
finish
only.
that.
What office?
Copy.
Not
Appeal
served on
copy,
you.
appeal copy is not.
And
from-
you have to file the application.
No only, sir.
Huh?
No only, sir.
Please, sir. You have the memo with you?
Uh,
A memo is filed seeking dispensation of notice to R1, as R1 was set ex parte before the trial, before the tribunal. The memo is taken on record and notice to R1 is dispensed with. Land counsel submits that he will serve the appeal memo on the counsel for the respondent insurance company. When do you want?
next week, you need.
This is a matter on
This is the
Yes,
only.
not
point.
on 21st. This is a matter on 28th. Yes,
Serial number 6.
Anita?
Huh?
I'm applying for the petitioner.
Thursday, 2 days. This is 2 days. Remind me. Yes.
I'm petitioner last year. They have filed by objection.
Huh?
Respondent filed by objection.
Who is
Serial number
R1?
R1 is one or not.
Its presence is required or not required?
It's not required.
Liability is on whom?
Respondent one.
Liability is on the insurance company.
Yes,
Then you file a memo for dispensation. Then we can pass orders. Where is the counsel, Mr. S.V. Hegde?
Patai. SV Hegde Mulkan for
See the
R2.
file, we'll see.
Yes.
We'll see. First respondent is held liable. Owner of the vehicle.
Yes. Second is insurance.
First respondent before the tribunal
Yes.
is the owner of the vehicle.
Yes.
He is held responsible, not the insurance company. First notice has to go to him.
Yes.
You have to pay the process. A week's time is granted to pay the process in respect of the first respondent, or else the appeal shall stand dismissed against the first respondent. Yes, 7.
Number 7.
Yes.
Serial number 7.
As per the order passed to this court, is taken out
Acceptance
notice
of
to the
application.
and so. And memo is filed for acceptance of the paper publication. Same is accepted and notice to R1 is held sufficient. Ready?
Yes, madam.
What is this case?
And this case with regard to the liability,
Huh?
liability
On what ground?
on the policy, the premium, the check given to the towards the premium of the insurance policy got
Date of accident?
date of accident, my lord. 11/12/2017.
When is the accident?
Pardon, my lord.
Accident.
So,
Date of
10/12/2017.
11/12/2017 is the accident.
Accident.
When check dated?
Para 36 में कहीं
Check dated?
Check dated 3/10/2017, returned and with the Shara insufficient fund on 6/10/2017.
6/10/2017. How
Notice
is it communicated?
communicated
Through
on
RPD.
through RPD by 7/10/2017. 7/10/2017, my lord.
RPAD.
Yes, my lord.
When was it received by you, by the concern?
Exhibit R6 is the post acknowledgement.
Postal acknowledgement
Date.
on 7/10, my lord. Same date.
It is received.
Yes, my lord.
Accident has happened on
11/12 after 2 months of the policy. So
what remains?
my submission is that to safeguard the interest of the third parties, pay and recover principles of private recovery has to be applied by the trial court as held by the apex court in Dadapa case.
Let's see. Please pass on. There are no contrary judgments to this.
No, nothing.
The
They also apply.
decision which is now refer is not applicable to my present case.
So the same
Let's
case
see,
only.
let's-
Nobody, sir.
Yes, yes.
Which paragraph?
Correct, but the main,
I am looking at Dadapa.
yes, my lord.
Which paragraph? If that has to be what is the understanding of the court is in this regard, the Honorable Supreme Court said this RPAD, if
the
it is served on
intimation
the
is not
intimation
certain.
it is in the knowledge of the owner of the vehicle before the accident, insurance company is not liable. It's what the Supreme, several judgments. I've also passed several orders. Wherever they have not come, though they have communicated,
Please.
not received the owner, then it is not a proper communication and they are liable to pay.
Yes, my lord.
That's how we have dealt with.
There will be no such pain recovery at that time. But
This is at
here
what
in this
time?
case, the same identical case.
2000, I have passed orders recently. Let's see. If that is the case, we will definitely look into it.
Yes, my lord.
Paragraph number? Copy is given to him?
No, copies, only one.
No, he assumed that you will be knowing. Yes.
Yes, my lord.
No problem.
Here, the main clause, the cancellation of liability of insurance check issue.
Paragraph number.
The main.
No, not head notes. Come to the paragraph.
Paragraph.
Which
yes.
paragraph?
Paragraph.
To paragraph number 26, straight away it
Yes,
answers.
yes, my lord.
It answers your.
We are not obviously of the distinction between the statutory liability of the insurance company, vice versa, third party in the context of section 147 and 149 of the Act and its liability in other cases. But the same liability arising under the contract of insurance would have to be met if the contract is valid. If the contract of insurance has been cancelled and all concerned have been intimated thereabout, we are hoping the insurance company would not be liable to satisfy the claim. Yes. The beneficial legislature is well known should not be construed in such a manner so that to bring within the ambit a benefit which has not contemplated by the legislature to be given to the party. In reason so and so, we do not doubt that beneficial legislation should have liberal construction with a view of implementing the legislation intent, but where such beneficial legislation has a scheme of its own, there is no warrant for the court to travel beyond the scheme and extend the scope of statute on the pretext of extending the statutory benefit to those who are not covered by the scheme. We therefore agree with the opinion of the High Court. However, as the appellant hails from the lowest strategy of the society, we are of the opinion that in the case of this nature, we should exercise.
So, court has done something under 142.
142.
That is not a precedent.
Yeah, that is not a precedent, but in our case also,
This court has no power under 142. But what we'll do is I'll dismiss this case. You have to go to the Supreme Court and relying on this judgment, Supreme Court will exercise 142. Please come.
The Leonard single judge of the High Court of.
Do it. The single judge might have done, but we cannot do it. How can we do it? What is the liability of the insurance company? Madras High Court, that has no only a persuasive value. I've already passed several orders in this. Agreed with orders passed in. Agreed with award passed in. MBC number 602 of 2017, dated 31st May 2023, whereby the liability is fixed on the owner of the vehicle. The claimant is before this court. The facts of this case are the deceased met with an accident on 11/12/2017 at 5 p.m. The claimants have filed this petition seeking compensation. How much is sought? Seeking compensation for the death of the deceased.
1 crore.
That came to be allowed.
1 crore was.
Seeking 1 crore compensation. And the court had granted 14,33,120. Interest at 9% per annum. When it comes to the liability is fixed on the owner of the vehicle on the ground that towards the premium amount, a check was given on 3/10/2017, and the same is returned for insufficient of funds on 6/10/2017. Immediately on 7/10/2017, the same is communicated to the owner of the vehicle and it was received, and the acknowledgement is marked as exhibit
R6.
Exhibit R6. Basing on this, the court has held that insurance company is not liable to pay the compensation. Next paragraph. Learned counsel appearing for the petitioner, for the appellant claimant, had relied on the judgment of the Honorable Apex Court in Dadappa and others versus Branch Manager National Insurance Company Limited, reported in 2008 ACJ 581, and also he has relied on another judgment of the Madras High Court in case of Prema and others versus Sampath Kumar and others, 2020 ACJ 2283. Relying on the Adappa's case, referred supra, Learned Counsel submits that at paragraph number 28, though in a similar facts and circumstances, the Honorable Apex Court observed that as the claimant hails from the lowest strata of society, they are of the opinion that in a case of this nature, in exercise of the extraordinary jurisdiction under Article 142 of the Constitution of India, direct the insurance company to pay the amount of claim and record the same from the owner of the vehicle. Then in judgment, in case of Prema and others referred supra, he relied on which paragraph?
Relied on the paragraphs of 12, my lord.
Paragraph number 12. Paragraph number 12. Then counsel submits that in this case also the pay and recover has to be applied, and the insurance company shall pay and recover the same from the owner, as it is a third party and it is a case of death. Next paragraph. When counsel appearing for the respondent submits that respondent insurance company, when there is no policy, the liability of the insurance company to pay the compensation will not arise. Pay and recover will apply as for the judgment of Swaran Singh's case and other judgments where there are certain violations of the terms and conditions of the policy. But here is a case where there is no policy at all in the eye of law. As such, the tribunal had rightly held that insurance company is not liable to pay the compensation. Next paragraph. Having heard the counsels on either side, there is a material on record. In this case, admittedly, the accident was on 11/12/2017, and for the policy premium, towards the premium, a check was issued on 3/10/2017. It was returned on 6/10/2017. The same was informed on 7/10/2017. The acknowledgement is also filed before the court. These are all the undisputed facts. Accident had taken place on 11/12/2017, much after the insurance policy is cancelled. In those circumstances, the question of liability of the insurance company cannot arise, will not arise. Insurance policy is a contract between the insurer and the insured. The Motor Vehicles Act is a beneficial legislation, considering certain aspects with regard to the permits, with regard to the driving license. On these aspects, the law is laid down with regard to pay and recover. But the court, considering the plight of the claimant, cannot impose an order on the insurance company to pay the amount and recover the same when there is no contract itself between the insurer and the insured and insurer and insured. The judgment that is relied on by the counsel as by the Honorable Apex Court, the invoking Article 142 of the Constitution of India, and it cannot be considered as a precedent. And this court, contrary to the settled law, cannot direct the insurance company to pay and recover in that view of the matter.
There is
The
a
tribunal
enhancement
has
of
right-
compensation.
Huh?
There is a enhancement of compensation.
What about the respondent in that case? Is
Yes,
served?
Ex parte, my lord.
Huh?
Ex parte. Respondent, owner of the.
Oh, this is R2. R1. Yes, yes. You are seeking enhancement.
Yes, yes, my lord.
What
Here
is
in
wrong?
this case, the deceased was working as a security guard and also doing agriculture work. So.
How much the court has taken?
7,965, my lord.
7,000?
Relying on the payslip of the salary. But on the day of the accident, he was going in a goods vehicle, taking the vegetables to Bangalore, coming from Ramnagar to Bangalore to sell it in the market. So with regard to that, we have not produced any income with regard to the income. So 2017 matter.
No. When you say this is my income,
Then
the court cannot take as for this whatever is the table. That is where there is no evidence with regard to income.
Yes, my lord.
For example, if you say my income is 8,000, because as per the table it is 16,000, we cannot take it.
Payslip was produced before the court.
7,000.
7,965 is given, but he was also doing the agriculture
For
work.
that there is evidence required.
There is in the complaint and also in the investigation. He is on the day of the accident, he was going.
So you should have said, what is the income is deriving from that?
Totally, he has said from all this 30,000 income as he was earning around 30,000.
Is it so?
Yes, my lord.
Then in that case, we can take which year is the accident?
At 17, my lord.
He said so, that he's earning 30,000?
But when the document was got produced before this court.
There is no.
That's what, when there is no evidence, that is where we rely on that.
No, the document was placed before the court to prove the
He's
income.
doing watchman, he's working
Please.
as a watchman.
Please.
He is doing agriculture and every day.
For that matter, no document was placed before the court.
No, you understand? 7,000 document. That's what is the notional income we consider. So why this is an exceptional case? I can understand he says, I'm earning only 7,000, no other work I'm doing.
Then it has
But
to
he said
be-
I'm doing something else also.
When he is working as a security guard, he cannot simultaneously doing
Why
the
can't,
agriculture.
if he's doing the night, if he's working as a watchman in the night time?
That is not the evidence of the petitioner.
What's the evidence
What is
given?
this evidence?
That
Yes, which year is the accident?
2017, my lord. 11,000 is the income. No?
What is the age?
Age, Lord,
36 years.
36. And one more submission, my lord. Here, the father of the deceased died during the pendency of the case before the trial court. So the tribunal has taken 1/3, leaving behind only 3 dependents.
1 minute. How many? 4 were the dependents as on the day?
No, actually, when the case was filed,
But I'm asking, 4 were the dependents?
Yes, my lord.
Yes.
1/4 has to be deducted.
What is the multiplier?
Multiplier 15, my lord. Yes, my lord. And loss of consumption only 40,000 was.
1 minute. Please wait.
ಅದಕ್ಕೆ 1/3 ಮಾತ್ರ
It comes to 23 lakhs 1,000. What was granted?
13 lakhs 38,120.
13 lakhs
38,120.
120. Please come. In his contentions, then counsel for the appellant claimant also submits that the insurance, according to his case, is working as a watchman and earning 7,965.
No, totally 30,000 per month. 7,965.
965. And also doing agriculture, and every day he is selling the vegetables, and with both is earning an amount of rupees 30,000. Court had taken 7,965.
Yes, ma'am.
Court had taken the 7,965, but had failed to take the income at 30,000, land council submits that. If not 30,000, as this accident had taken place in the year 2017, the court ought to have taken 11,000. The next para, after this, coming to the compensation. What was the last line? Rightly held that the insurance company is not liable. Then coming to the compensation. Next, after that, notice to the owner of the vehicle, the petitioner, the appellant, as per the order passed by this court, had taken substituted service, notice by way of substituted service, and this court, by order dated so and so, held that notice to the respondent 1 is sufficient. Next, that order I have dictated, that should be the docket order. Then it is a submission that the court had taken 7,965. According to the claimant, he is earning 30,000. No doubt there is nothing to prove that he is getting income out of agriculture. In that, and court had rightly not taken 30,000, but it ought to have taken 11,000 as per the table. Hence, this court is taking the income at 11,000. It is also submitted that, in his submissions also you're right, it is submitted that the father died during the pendency of the trial. The court had taken 1/3. They had deducted 1/3. It should have been 1/4. In the continuation of the order also. The court, the father was there as on the date of accident. Introductory of the matter, the court ought to have taken, deducted 1/4, but not 1/3. If the 11,000 is taken as income, 40% future prospects would come to 4,400. That is 15,400. The 1/4 is 3,850, and if the same is deducted, it comes to 11,550. Is contribution to the family. Into 12 into 15 is 20,79,000 towards consortium. 1 into 44, 1,76,000. Funeral expenses 36,000. In the light of the law laid down in Mekala versus so and so, 10,000. Altogether, the claimant is entitled for an amount of rupees 23,01,000. Accordingly, the appeal is partly allowed, enhancing the compensation from 13,38,120 to 23,01,000, and the amount the owner alone is liable to pay the compensation. Accordingly, the appeal is partly allowed. Yes, next.
Cell number 8. Cell
Yes.
number 8, A.M. Venkatesh for appellant.
Steps to be taken in respect of R3 since unserved received with a shara. Address death.
Reported to be dead, my lord.
Huh?
I filed the necessary memo to treat the other claimants as is a loss, my lord.
You should do it. It's an MFA of 2023. How long will be keeping it? When was
next
this,
week. Next
when
week
was
we'll
this post, the postal shara? When did you come to know about the death?
Only today it is posted, madam.
Huh? Yes, let's see. You that? At least insurance companies shall not show some interest to proceed with the matters, or is what a interest who will pay for years together.
My lord, it may be taken up next week, my lord. I will do it. I will complete the matter.
No, before that we'll clarify this. What is this? Where do you get that?
My lord, he is dead. The other LRs represents him.
1 minute. When there is no relief against them, why should the LRs be brought?
My lord, because he is one of the petitioners.
Petitioners, 1 minute.
My lord, he is one
Petitioner
of the,
1 and 2 are entitled for compensation.
my lord, he is one of the claimants in the petition. Therefore, it was brought. In the judgment, it is so. It is judgment, it is so. My lord, no relief may be given, but in the judgment, he is one of the party. Therefore, he was made a party respondent here. Formal party, maybe, but I cannot give him.
You can't give up. What do you want again?
Now I will file a memo.
You want some order to be given in your appeal to the third respondent? When the trial court, please listen,
now
Mr.
I will file a memo. The other LRs may be treated as a loss of this person.
The court had granted compensation to
Yes,
1 and 2.
1 and 2.
You question that compensation granted to 1 and 2
Yes.
before this court.
Yes.
And you want 3 to be represented.
But in the judgment, all the 5 respondents are there.
I will record that, not necessary, no application, nothing necessary. This is matter on.
My lord, I'll file memo to that effect.
Want to file, this is matter on 3rd of on 28th of September. No further adjournments. On the day the matter will be heard and orders will be passed. Yes, 9.
Number 9.
You said you will file it at a later point of time. Take that.
I am filing better affidavit. In the
What is the age of the third respondent? Then she must be married by this time. How can we take this memo, Mr. Venkatesh? I will record that. How can a married person which represented, the LRs are already, brothers are there, so it is sufficient. How can it be? 26 years old at that time, and she is married, and now you say that brother and sister are there on record. That is not either this is a procedure or the earlier one is a procedure. I will pass orders. You please come on that day. Yes, next.
Number 9.
How can we give shorter date? Because there are already so many matters given by that time.
28.
Everybody will keep quiet from 22. Suddenly, whenever the matter comes before the court, you start that as if heavens are not going to fall. It will come on that day. Yes.
Serial number 9. Leeladhar HP.
yes, I am filing better affidavit, Your Lordship. Last time the Ahmedabad court has been submitted. Because the petitioner died. Petitioner died.
What is this case? RPFC. Petitioner is who? The husband.
I will submit it. Petitioner died. He having a living
Petitioner is wife or husband?
Yes.
Petitioner is
My submission, Your Lordship.
husband. Amaresh.
The respondent, who is the married wife, left the house. Thereafter, the petitioner having developed with a love affairs with the father of the LS.
What is the impugned order?
Impugned order, Your Lordship, is internal page. Internal page. Huh? Yes. Internal page, Your Lordship, 41. It has been passed. The respondent hereby directed to pay monthly maintenance of 20,000 to the petitioners from the date of the petition till her life. The respondent shall also pay litigation expenses 5,000 rupees. This is the order passed by the family court. Against third order, Your Lordship, I filed this petition. Your
You are who? You are the wife or the husband?
Original petitioner is the husband. Original petitioner is the husband. That is, Amaresh is the husband. He is the respondent in the trial court. He is the respondent in the trial court. During the pendency of this appeal, Your Lordship, he died. What happened, Your Lordship? The Amaresh, the first wife, left the house of the petitioner and she started residing in Madras. He come with contact with one Bhagyamma. Out of the love affairs, she got 2 children. They are now claiming before this honorable court as the LRs of Amaresh. So that I filed the application as to bring them as an LRs to see that to contest the case where injustice caused to her parents.
Where is the affidavit?
Injustice caused to her parents.
Please come to the affidavit.
Yes, Your Honor. I stated in para number. Internal page 4, you typed page 4, Your Honor. That is internal page, in page 2, Your Honor, para number 4. I submit my father Amaresh Shankrappa is also one of the having son by name Savitramma. After the death of our grandfather, namely Shankrappa, the scheduled property bearing number 19 KV Lane, Cottonpete, Bangalore is absolute property of Savitramma. In order to protect the interest of the petitioner, Srimati Savitrama executed a registered will dated 13/12/2019, incorporating that Amaresh, who is my father, he was living in relationship with Srimati Bhagyavat, daughter of Narayan Reddy. Out of the relationship, Amaresh and Bhagyavati, two female children were born, namely Kumari Upasana A and Kumari Chandrakumari. These are the LRs now, the common record. And this fact is also not disputed by the
Let us see their application.
respondent.
Where is your IA? Incomplete petition. Where is the incomplete petition?
I myself has filed in pleading.
Where is that?
That application was on dated 21 January 2025 I filed it.
21?
Last time ತಾವು ಹೇಳಿದ್ರಿ ಅದು affidavit ನೋಡ್ಬಿಟ್ಟು better affidavit ಹಾಕ್ರಿ ಅಂತ ಹೇಳಿ.
Let us see where is that affidavit.
Yes, you are also, it is application filed on 21 January 2025.
January
21st January 2025.
IA number, sir.
The EA number. ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿತ್ತು ಅದು ಲಿಸ್ಟ್ ಅಲ್ಲಿ. ಆಯ್ತು ಎಸ್ ಎಸ್ 21st January 2025. Producing.
Savitrama will produce ಮಾಡಿರೋದು
ಹಾಗೆ ಅದು ಏನೋ ಇದನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಾ ಸ್ಟೇಜ್ ಜೊತೆ ಮಾಡಿದ್ವಲ್ವಾ.
Who are this Upasana and
She is Chandramukhi, daughter of Amarish. He having first wife, that is the respondent herein, left by the husband's house and started living in Madras. He came in contact with Bhagyamati, that is the mother of these husband. And out of the relationship as a husband and wife, there's the live-in relationship, two children has been born. They are the petitioners here. And it is an admitted fact, a registered will has been executed by the original petitioner's mother, registered will, where she also incorporated, said words, your worship, I have produced the will copy also, your worship. It is.
What do you say? No, but here it is this. Now, if I dismiss this, you will be the one who will be at stake, because what happens is, now I say that husband is no more. It has become it's abated and I dismiss it. That's what I'm saying. Who will deposit? So you are not interested to pursue it. Whatever, how much amount is lying there?
ಯಾವ ಆರ್ಡರ್? Now, your lordship, see order dated 17/2/2023 passed by this honorable court. Please, sir, Sagar Gelton, please. 17/12/2023, your lordship.
Let him see. Yes.
Please, your para number 3, your lordship.
Hmm.
The petitioner has filed an affidavit stating that the shop number 50 is leased in favor of Ratna. One Ratna, however, she is refuted the same by the respondent stating that shop was leased in favor of Ratnam by the petitioner. There is controversy regarding the leasing of the shop number 50. Hence, the allotment of tenancy in respect of shop number 50 cannot be executed till controversy is resolved. Then you are asked. Then, after para number 6, then the petitioner is agreeable to pay just and proper maintenance to the respondent as may be determined by this honorable court in lieu of the respondent executed deed of assignment tenancy in respect of shop number 45 and 50. This shop number 45, 50 has been given to the respondent for her maintenance, my grandmother, in the registered will, and also in residential accommodation in the very same building that has been given to the respondent for her residence.
No, I understood. Please come to the impugned order. Come to the impugned order. Please read. What are the findings which are not?
Yes, you are right. Yes. Before that one, your lordship, I produced the additional document, that is evidence tendered by her in the trial court. Evidence tendered by her in the trial.
Let us read the impugned order first.
Yes, I will take your lordship. Yes, you are right. Impugned order. Yes, you are right.
Let him argue, because I have to pass orders. I have to understand what is his contention.
Yes, sir. The impugned order, your lordship. First of all, your lordship, what is my objection to the application filed by the respondent yourself? Your lordship, it is started from internal page 22, ink page number 22, your lordship. Para number 6 in the impugned order. Respondent appeared through his counsel and filed objection where he admitted the relationship with the petitioner. However, denied all other allegations which are traversed against his contention. His case is that marriage with the petitioner was celebrated on 1911 to 1986. The petitioner hails from Madras, having residence at Pattur Street, Saidapeta, Madras. After she conceiving for the first time, she went to her parental house, where she underwent abortion, and thereafter she did not return to the matrimonial home till 1991. As the petitioner deserted him, 1981 to 1991, he developed an intimacy with one Bhagya, and now they are living with the 2 children, Upasana and Chandramukhi, age about 22 years and 19 years, respectively, and they are studying. The petitioner, after coming to know about the said fact, returned to Bangalore in 1991 and forcefully reside with his mother, 19 KV Lane, Cottonpete, Bangalore, where she has been, my mother has been accommodated for living. The respondent further contended that the petitioner, with the help of influential brothers, tried to dispossess her mother-in-law from the said property and obtain signature on blank papers when the respondent was not in session. Accordingly, his mother filed OS number 10447/92, in which interim order has been passed against the petitioner and her brother, that the petitioner illiterate him, and also his mother is in all manner that due to the adamant attitude and audacity of the petitioner, he found difficult to continue matrimonial relationship with her, as there are chances of danger to his life and his mother. In order to overcome the same, for the livelihood of the petitioner, he has given up 2 shops bearing number 45 and 50, situated at Seturao Street, KR Market, Bangalore. It is a commercial area, your lordship, wholesale coconut market, in which the father carrying on the wholesale business of coconut, and his mother is allowed the petitioner to reside in the front of the first floor premises in 19 KV Lane, Cottonpate, till her death of the petitioner, without having any manner of right, title, interest as a licensee. That she above the said suit filed by his mother was written on the judicial matter, and the same was filed in OS number 113/92 before the family court, Bangalore. The petitioner, having knowledge about the relationship with Bhagya, kept quiet and started to lodge false complaint against his family members, harassed them that his mother bequeathed all her properties by executing a registered will dated 13/2/1999. Petitioner is allowed to enjoy the shop number 4550 as a licensee. That MC number 1152/99 filed by him for dissolution of the marriage on the ground of fealty and desertion, dismissed on 24/1/2006. That criminal miss number 1064/2026 filed by the petitioner under section 12 of the Protection of Women from Domestic Violence Act came to be dismissed. That as the petitioner failed in all her attempts to harass and to extract money from him, PCR number 15924/2008 filed under section 498A and section 506B, read with section 120B IPC, numbered as CC number so and so, which was dismissed on merit, with order dated 24/3/2016, that when she was given residential accommodation till her death in premises number 19 and shops 45 and 50 are given to her living out of the rents filing by the parents' application is not maintainable, and the question of granting maintenance once again does not arise at all. This is the fact your laws have stated. Because her maintenance to coconut shops, that is in the wholesale market in coconut can given to her. At that time, she was getting a.
First of all, he is no more. These people cannot be. This court cannot consider them as LRs of the deceased. So once we dismiss that application, nothing remains in this petition. It has to go. Whatever amount that is deposited by the petitioner, he has to withdraw the
Your Lordship, see the art of this honorable court and
seen that.
what happened, Your Lordship, what the court honorable says that Your Lordship, interim order paid by subject to the following condition. Petitioner shall deposit a sum of 8 lakh before the court within 2 weeks. On deposit of the said amount, respondent shall execute a deed of attornment of tenancy in favor of the petitioner in respect of the shop number 45 situated SRS market, KR market within 2 weeks. This has not been complied them. This has not been complied them.
Please come.
Execution of the attornment tenancy of the respondent in favor of the petitioner. The respondent is permitted to withdraw. The attornment and execute withdraw permission for the honorable court. Then you are also, the impugned judgment I will submit before the honorable court.
We cannot decide the impugned judgment because he is no more and nobody can contest.
Only what I am submitting here, an amount has been charged against him. That is 20,000 rupees per month. From the date of the petition, your Lordship see that the implication of the order. From the date of the petition, the honorable court awarded 20,000 per month. What I have stated in the trial court, 2 shops has been given to her, which is at least getting a sum of 5,000 rupees each from the shop. That is a wholesale coconut merchant. Then we are also given an accommodation in the first floor by my mother. These 3 aspects has not been taken into consideration. Yes, Your Honor.
Please come.
That has not been taken into consideration.
The order passed in Miscellaneous number 317 of 2016, dated 9th February 2022, whereby the court had granted 40,000, 20,000 as maintenance, and litigation or expenses of rupees 5,000. The husband is before this court. Now it is brought to the notice of the court that husband is no more, and he died on.
Died and I submitted it. Put the death certificate also. Your Honor.
He died on what? Please give the date.
I will submit it. He died on 29/11/2024.
29/11/2024.
Yes, Your Honor.
And now LR petition is placed before the court. It is the case that the respondent is married to the petitioner, and after some time she left to her parents' house. Then he has come in contact with one Bhagya, and they started living together. And they have 2 female children. And the female children. The wife, respondent herein, started residing with the mother of the petitioner. Now, as the petitioner died, the children born to Bhagyama, born through Bhagyama, are the legal heads of the deceased. As such, they shall be brought on record as the LRs of the deceased. On the face of it, considering the affidavit that is filed before the court and the submissions made before this court cannot allow such an application where the children, there is no dispute that the marriage between the petitioner and the respondent was in subsistence till the day he died. And it is a case that he is having an extramarital relationship with one Bhagyama and Bhagya, and in that there are two children. And this court, by allowing this application, would be declaring them as the legal representatives of the deceased, which this court cannot do, and we cannot consider them as a legal representatives of the deceased. In that view of the matter, the IA that is filed to implead the legal representative is dismissed. If they claim themselves to be the legal representatives, it is for them to file an appropriate suit and get them declared as a legal representatives of the deceased. The next point that is urged is this court, by order dated 17/2/2023, a coordinate bench of this court has passed an order that the husband shall deposit a sum of rupees 8 lakhs before this court within 2 weeks from today, 2 weeks from the date of order, and on deposit of the amount, the wife shall execute a deed for atonement of tenancy in favor of the husband in respect of shop number 45, situated at SRS Street, KR Market, within 2 weeks. On execution of the deed of atonement of tenancy by the wife in favor of the husband, the wife is permitted to withdraw the amount of rupees 8 lakhs deposited by the husband before this court. Land counsel for the petitioner submits that as this order is not complied with, and the wife cannot withdraw the amount. Next one. The petitioner and the respondents are legally wedded wife and husband is an undisputed fact. The husband, there were disputes between the wife and the husband. Wife had filed a petition for maintenance. Court has granted maintenance. Now the husband is no more. Admittedly, there are no children in the wedlock. And now wife is the only surviving legal heir of the husband. Now the question of the issue executing an atonement in respect of the shop in favor of the husband will not arise as he is no more. In that view of the matter, as the petition that is filed by the husband is dismissed as abated, and whatever the amount that is deposited by the husband, the respondent is entitled to withdraw. Accordingly, the writ petition is dismissed.
Only one submission. Respondent herself admitted the relationship of the petitioner, original petitioner, and the Bhagyam. One nimsham.
Let him say.
It is an admitted fact. Because in our evidence is also in the trial court, she admitted that petitioner married with living relations with Bhagyam, having 2 children. No dispute at all. She admitted. I will read only one paragraph.
I'll tell you one thing.
Yes,
Please listen to the
why I am
court.
submitting your answer? Why I am submitting?
I understand what you are submitting.
Granting of maintenance from the date of petitioner is totally illegal. What I am submitting your answer from the date of petition, let them grant it.
No more. petitioner is no more, you cannot agitate all those issues now unless and until somebody is there to know the one who has given wakalat to you is no more. And the respondents whom you want to implead them as LRs, they are not the LRs. Then what is admitted by admitting a relationship, it cannot be given the legal sanctity.
In the court itself, Your Lordship, in the evidence,
Yes.
in
Next,
the evidence
next.
itself.
Yes, yes,
And
next.
So far, my submission, Your Lordship, so far,
Then it comes to for the
withdrawal of money, Your Lordship,
petitioner,
one nimsha. Withdrawal of money may be, Your Lordship, kept in vigilance 1 month, Your Lordship, my client, I will discuss with my client and submit to before the honorable
Yes,
court.
next.
Cell number 10, Mohammed Sahega.
Yes.
This is
What
87,
is council submission?
Lord, 87 days delay.
Huh?
There is delay of 87 days, Lord.
Non-compliance of office objections, council submission. What is the office objection? What is your submission?
Complied, my Lord. Again, repeatedly, it was come.
With regard to the office objection number 4, one more criminal miscellaneous is filed where the learned trial court have ordered NBW against the petition and stay is requested. What is this?
No,
Prayer para IA to be clarified with respect of challenging impugned order number so and so 47 of 2022.
my Lord, based on that order, next year, impugned order, another criminal miscellaneous filed by the respondent,
Please come to the impugned order. What is impugned order?
5,000 each, my Lord.
Page number.
Page number 13, my Lord. 13 to 21.
This order is dated 19th August 2024.
Yes, my Lord.
Then you have filed this RPFC. There is no, how much is the delay?
87 days, my Lord.
I'm not able to understand what is this council submission, what is office objection.
My Lord, based on this order, my Lord, for recovery of amount awarded, the respondent filed another criminal miscellaneous. In that, NBW has been issued. For that, I sought for a stay, my Lord. ಅದು ಕೊಟ್ಟಿದ್ವಿ ಅಮ್ಮ, ಬೇರೆ ಕಾಪಿ ಕೊಟ್ಟು ಹೇಳಿದ್ವಿ ಅದು.
How can it be granted?
Lord?
How can it be granted? That order is not, that where NBWs are issued, that is not questioned here.
That is questioned, my Lord. Stay of that
Office
order.
objections to be complied with. Office objections are sustained. Yes, next.
Cell number 11. Cell number 11,
Give that.
Shivan Agol.
This order is passed in I number 2, wherein the court had granted interim maintenance of an amount of rupees 8,000 per month to the respondents towards their maintenance. That order is questioned by filing RPFC, and the office has raised an objection with regard to the maintainability in view of section 19(4) of the Act. The office objections or the office objections are valid. The petition is dismissed with the liberty to file an appropriate application within a period of 1 week from today. Office shall return all the documents.
Number 12, Priyanka Kumari.
For the petitioner, my lordship.
This also against interlocutory order.
My lordship, interlocutory order, but this.
It's an interlocutory order, interim maintenance.
It is, he has been, the petitioner has been sent to jail, my lordship. And he moved application through jail authority. He hired some advocate and he moved application to release him as there is sufficient ground that he doesn't have money to pay. He is a coolie. He is a coolie, my lordship.
Let's see where is the order.
As soon, my lordship. Page number 22, my lordship.
20?
Page number 22.
22.
Yes.
22, by virtue of this order, court has granted.
23 in the end, the application filed by the respondent under section 125 clause 3 of CRPC is hereby rejected. And then
That's why it's a final order.
my lord,
Then why the RPFC not maintainable?
but this is a final order in respect of the enforceability of this maintenance order. So it should be maintainable, my lordship.
Not an IA, this is 125 CRPC. Where did you say so? It's not on IA. One 25.
And continuous, my lordship, he is continuously being sent to jail.
CRPC.
Every month continuously he is being sent to jail, my lordship. Every month he is being proposed.
Why did you not appeal against that order?
My lordship, that is another issue. Another issue because I am not able to submit with memorandum of facts regarding that because the party is claiming he is in jail. From there for 10 minutes he has called me.
What application he can file before the trial court? Can't he question the original order?
My lord, same I am explaining. For the original order, the party is, as per his version, he is not knowing anything that any maintenance application was filed.
He knows.
Now
he knows.
this case, he knows. The moment he knows, he comes to the court, he is being sent to the jail. From there, he is filing this.
That's what I'm saying. Instead of filing that application, you should have questioned the original order.
Original order, let me explain, my lordship. Then, my lordship, whatever what he is now telling that he was not knowing any maintenance petition filed under criminal miss 18. An order of maintenance was passed, but if I am going to I asked them to send me the entire order sheet of that case. Therein, what I am seeing that some advocate is representing him. And continuously he had represented him, and at one moment he is telling that I will file memo for non-instructions, but even then he is not filing. No objection, nothing, no argument, nothing has been filed, but this advocate continued till end, and before the final order is being passed, he is taking retirement. And this person petitioner is telling, I don't.
Does it change all these facts? Now you have submitted all these facts. How is it going to change the situation?
My lordship,
whatever it is, that original order
yes,
needs
my
to be
lordship,
questioned.
I will challenge. My only submission is, my lordship, till the time he is behind the bars.
We will not. You file, you
My
convert it
lordship,
into that.
he is behind the bar. I am not able to take instructions from him.
Then that's not the problem of the court. The original order remains unchallenged, and the petitioner is at liberty to challenge the order granting maintenance accordingly. The order, this RPFC dated so and so is dismissed, giving liberty to the petitioner to challenge the order of maintenance that is granted by the court. Yes.
Cell number 13. Srinivasa DC.
In this case, hand summons was not served. Petitioner hand summons was taken. Was not for the petitioner. Mother was ill. It's not something was written in the hand. Mainly initial hand.
Hand summons, what happened?
Was taken from the court, my lords. Petitioner was ill. Petitioner's mother was ill. He was not able to come and collect the hand summons, my lord. I request you to reissue hand summons, my lord.
Counsel is permitted to, the learned counsel appearing for the petitioner is permitted to take out hand summons on the counsel appearing for the respondent. Where from this petitioner mother has come in picture? Finally, the one more opportunity is given to the counsel for the petitioner to serve the hand summons on the counsel for the respondent and file a memo to that effect by 29th of August. Look at it. If there is any stay, the stay will be vacated. If it is not, writ petition will be dismissed. Yes, 14.
Till number 14.
For the petitioner, my lord.
Bindu, you.
In this case,
Acceptance of
office
court.
objection is with respect
I
to.
appear for
the-
respondent, my lords.
Yes, my lords. Now,
Lordship may direct the petitioner to serve the copy of writ petition, my lords.
I have
haven't
already
received.
given the process. It is there in the file. I have given the process and along with
You
that
look at
respondent
sir.
copies also
No,
that I
no.
may be permitted to take out. No, at the time of filing caveat was there. Subsequently caveat not
Now,
applied
let's
there.
not complicate this. He is here. Serve
Yes,
the
my lords.
papers.
I may be permitted to take out. I have given the process along with the respondent copy in the
If
file.
it is there, give him a copy. Yes, then counsel for the petition submits such, she will serve the copy of the writ petition on the counsel for the respondent. List this matter on 1st of September. Yes, next 15.
Till number 15.
In this, my lords, we have served the
Okay.
petition copy through WhatsApp, my lords. What happened is, my lords, there was some miscommunication, my lords. That's why
We will not, in every case, we will not pass 2-3 orders for the hand summons.
My lords,
If advocate is not
my lords, we have
understanding, they're
informed.
doing so at the risk of their clients. We can't help it.
My lords, we have.
What is this every time? In every case, everybody says that we have not understood why the order is not displayed on the website.
Please, my lords, what happened is, my lords, we have.
Unnecessarily matters are listed every
We
day
have
for these
called
kind
him
of
and
you
also informed
give
him.
that.
We have taken process also, my lords. On next date only, we have taken, my lords.
Then what is to be done? Interim order is there in this.
My lords.
Are you complying with the interim order?
My lords, still 4 weeks is there, my lords. He's arranging the funds, my lords.
How much you have paid? This order is passed on 23/7/2025.
23/7, my lords.
For August, by 5th of August, how much is paid?
My lords,
Get the instructions tomorrow. If by the amount is not paid as per the order of the court per month, look at that order. By August 5th, if the amount is not paid, the stay granted by this court stands vacated. Tomorrow.
Interim order, my lords.
Interim order is extended till tomorrow.
Cell number 16. Cell number 16.
Memo filed, madam. Memo
No,
filed
madam,
with
KP.
regard to service of notice to the counsel for the respondent in
Where
the
is that?
trial court, madam. Memo filed in the counter, madam. Both counsel and as well as respondent also, madam.
Where is the council's name?
Madam, there is a signature in the,
Please, what I request the advocate says, I can't read the signatures. That's why I'm
Yeah,
specifically
enrollment-
asking.
they wrote a enrollment number, madam. KR 2847 of it.
The counsel for the petitioner, give it to him. Shall mention the name of the counsel and then call the matter next again. Please write it in the memo, what is the name of the counsel. Next 17,
Pass order.
yes.
Till
Let
number
him
7.
write the name, I will, now itself it will be called. The 17,
17. Praveen, yes, for petitioner.
yes,
Kindly pass it over. Appearing for 17, madam.
yes.
Kindly pass it over.
What pass over?
Lordship, I'm instructed to file power for the respondent.
They have raised an objection with regard to the maintainability granting questioning 2 IAs in one writ petition. So first they have to comply with that.
Write down the name, your name.
The office has taken an objection with regard to filing the writ petition with regard to 2 different IAs. The office objections are sustained and the petitioner shall file 2 writ petitions questioning the order in 2 IAs. Yes. And the office objection shall be complied with within a week. Yes.
Well, kindly post it on
Cell
18.
number
18. But I just kindly post it on 18. madam. 18.
Yes, next.
Hearing on interlocutor application, cell number 18. HP Ganesh Gowda.
Yes.
I'm for the respondent in this case, my lord. Respondent number 2. My lord, in this case, there are 2 connected matters. MF 8780, the 385, my lord. My instructions are that, and there is also a copy of the order sheet wherein 385 has been closed by the tribunal below.
What close?
My lord,
What is close?
MFA 385 is fully satisfied by the appellant before the tribunal.
Hmm. Appellant is a?
That is owner's appeal, my lord.
He has
Owner has
satisfied,
paid the entire amount.
he has paid the entire amount, and the execution came to be closed before the
Closed in
tribunal.
385. Then what is next one?
In 8780, my lord, he has paid up to 2,85,000 rupees.
You are appearing for the owner of the vehicle.
And this matter may be referred to Lok Adalat where they can settle this matter.
Then counsel appearing for the owner of the vehicle submits that in MFA 385 of 2022, he has satisfied he deposited the entire amount. And it is submitted that in there is a likelihood of settlement and the matters may be referred to Lok Adalat. Accordingly,
Please.
the petitions are referred to the Lok Adalat.
Much obliged.
Yes. Yes, what is the name of the advocate?
Vandana R, ma'am.
Vandana?
Vandana R, my lord.
It is submitted that as per the order passed by this court, the counsel has served the notice on the counsel appearing for the respondent before the trial court. That is advocate by name Vandana R. Warrant filed a memo to that effect. Accordingly, notice to the respondent is self-sufficient. Print the name of the advocate and list this matter on 3rd of September. Yes, next.
Cell number 19. 19.
Yes, I have 1 of 25
It is in Vijay Karnataka Bangalore edition.
and 1 of 84, 25 is filed same. So and so, mentioning the date of hearing.
28 draft and 15/9 hearing. date.
Yes.
Cell
Tata
number-
AG Insurance, who appears?
Tata manager Tata AIG.
Mr. Janardhan Reddy is directed to take notice on behalf of the respondent to insurance company and the counsel for the appellant shall serve the copy of the appeal memo on the counsel. Yes, print the name of Mr. Janardhan Reddy. Yes.
Cell number 20. Kavita HC for appellant. T. Shankar Reddy.
Condone the delay. Is not there, will condone the delay and post it for hearing. There is no representation on the behalf of the appellant. I number 1 of 23 is filed to condone the delay of 55 days in filing the appeal. Considering the reasons stated in the accompanying affidavit, the delay is condoned. Admit, post for final hearing, call for the DCR. Next 21.
Cell number 21. Pawan TG for appellant.
Who appears for this KSRTC Hassan?
SRTC. That FS Dabali.
HR Renuka. Print the name of HR Renuka for the respondent insurance for the respondent KSRTC. IN number 1 of 23 is filed to condone the delay of 59 days in filing. Same for the reasons stated, condoned. Counsel for the appellant is not present before the court. The appellant shall serve the copy of the appeal memo on the counsel appearing for the respondent. Please admit, post for final hearing TCR. Next 22.
Cell number 22. Ramachandra.
Huh? You are for the owner of the vehicle.
Yes, sir. But the Maruti van.
Then counsel has filed a memo to the before this court that he has already deposited an amount of rupees 1,50,000 before the tribunal. You are for the claimant. Let them withdraw the amount.
No,
How much is granted?
no, in fact, 4 lakh something. I will, no, because the dispute is because he has not produced a MU report and there is a inaudited delay in filing the claim petition.
How much delay?
For 2 years and 2.5 years.
Admit, post for final hearing, call for the DCR.
Yes, should be fine.
Yes, next.
590 days.
Then this delay on condition. What condition he is on? IA number 1 of 23 is filed to condone the delay of 590 days, 6 days in filing the appeal. No objections are filed with the respondent.
I will furnish.
And the delay is for the reasons stated, condoned. Give him the
Yes,
copy.
I will.
Today itself you give.
No, why?
Yes, next.
Serial number 23 urgent, 24 urgent, serial number 25,
Yes,
Habibullah.
notice. Notice to the respondent.
No, Your Honor, stay is required, Your Honor.
Huh?
Stay in this case is required, Your
Then
Honor.
why did you come 130 with delay of 133 days when stay is required?
He is an illiterate fellow, he don't know the procedure.
How much is the amount granted by the court?
9,000, Your Honor, 4,000 each, Your Honor. But
Also-
actually, the wife is not a legally wedded wife. The respondent is not a legally wedded wife of this
But
petitioner.
you accept that they are your children?
No, Your Honor.
Huh?
Not, we are not accepted.
Let's see the order.
See,
Come to the order. Exhibits P2, 3, 4 and 6, what are they?
please, Your Honor.
Exhibit P2, 3, 4 and 6, what are they? Anyhow, all these things we will decide once they come. How much you are ready to pay now? Yes, Mr.
Rent
Counsel.
agreement, the mother card that
How
not
much you are
related.
ready to pay now? All these things we will decide once the respondent comes.
But there is no relationship between me and that respondent, Your Honor. First thing is, we are in only.
Where
in-
is that exhibit P2 that you have the documents?
No, Your
If you
mother
want the
card,
court to
mother
grant
card.
any interim order blanket, you have to convince the court that there is no relationship basing
There
on
are
the
living
evidence.
relationship only with between this petitioner and the respondent. Living relationship only, not husband and wife's relationship.
Then what about children?
Actually, now she is also not continue to live with. So he is filing this false cases and harassing this
No, it's
petitioner.
very
That's it.
simple. She is not your wife.
Yes, of course.
The children are born in the relation or not?
That is also doubtful, Your Honor. That is
Doubtful,
also,
you
it's
can't
not
say-
clear. That's also,
If
but
you are ready to deposit half of the amount, will grant stay or else no.
please, Your Honor, but he is a goat ad, kuri kaya, please, he don't
4,000
having that
he
in
can
the,
pay.
only 150 or 200 he is getting every day, out of which he has to pay rent. He has old age mother also, and have to maintain family.
You can have relationships, you can have children, but you will not pay maintenance to them.
But
Notice to the respondent, no stay.
No, Your Honor, but if he is sent to the custody, that will, they will also suffer.
Let
They
them
will
suffer.
only,
Let them suffer.
Serial number
You know,
20.
please, Your Honor.
He's outside also. He's
Actually,
not.
when he is not, she is
Mr.
not her
Counsel,
wife.
half of the amount you are ready to pay will grant stay or else no. It's not going to make any difference any of the
We will
submission.
continue to pay the maintenance at any, please, this amount is very much huge amount, Your Honor. 3
I
lakhs
said
98,000.
4,000. Arrears also have to
Highly
pay.
impossible for him. He is a goat ad, Your Honor.
Notice
Kurika,
to
he
the
don't having that
respondents.
any source.
Yes.
Very
Amendment
much.
Issue notice to the respondents.
Please.
Next 26.
Serial number 26.
Please stay for, at least for, not, that much amount is not possible to deposit.
How much he'll pay?
That is also, I don't know. I had to ask for that, please.
Then you ask him
At
and
least,
then argue.
at least for a 1 hearing, you will please kindly stay for next date of hearing, at least, Your Honor. If stay is not granted, he
So
will
when
be,
you're making submissions before the High Court,
Yes,
at
Your
least you be conscious of it.
yes,
And please get instructions and come back. Don't make
Of
these
course.
kind of submissions.
of course, Your Honor, but
Please call the next matter.
Fast forward, ma'am.
please, Your Honor.
Notice.
Notice. Serial number 26. Sachin BS.
There is a delay. Appear for
The
the
reasons for the delay of 907 days, let us see.
Alerts. I was served. I am.
Let's see. Let's read the reasons that you have stated in the affidavit.
Please, my lords. Page number 32, my lords.
Please read.
Please, my lords. From para 4, my lords, I state that the impugned order was passed on 7/11/2022. However, the order was not communicated
According to you, who will communicate? Judge will come and give you.
my lords. Notice was not served upon me, my lords. Within 2 months, my lords, the order was passed.
Let's see the order.
Please, my
What
lords.
the court said about notice to you.
Please, my lords. In my lords, page number 22, my lords. Page number 22, my lords. Petitioner absent, notice to the respondent duly served, called out, and the absent notice sufficient for the evidence of the petition. Petitioner absent, time granted for the petitioner evidence.
So when did you come to know?
Please, my lords, I come to know, my lords, recently.
Say, I was unable to engage a counsel to represent my case before the court. Subsequently, after a lapse of several months,
Please,
I came to know about the order. So with these kind of events, a delay of how many?
Please, my lords, 900,
And how many years
3 years almost.
will be condoned with this affidavit?
No, my lords. Notice may be issued, my
No,
lords.
no, not at all.
My lords,
Come.
it was not at all
Let
informed
it
to you, my
be.
lords.
What is this affidavit? Please tell the court. What is the
Please,
purpose of filing an application
Please,
under
ma'am.
section 5?
Please, ma'am, to state the genuine reasons.
And
Please,
907 days,
Please, ma'am.
inordinate delay, what the affidavit should contain? I came to know several days back.
Yes.
Several days back, something happened. That itself shows that there is
Apology,
no
ma'am.
bona fide.
That is what instructed, my lords.
The I
Please,
number
my lords.
1 of 25 is filed to condone the delay of 907 days in filing the petition. In support of the IA that's filed under section 5 of the Limitation Act, it is stated that the impugned order is passed on 7/11/2022. However, the said order was not communicated to the petitioner due to the financial condition and the short notice of the proceedings. He was unable to engage a counsel to represent the case before the court. Subsequently, after a lapse of several months, he came to know about the order passed by the court. Thereafter, he applied for a certified copy of the order. After receiving the copy application of the order, he has approached the local advocate to secure legal opinion. The local advocate took some time to go through the record and to give legal opinion. The advocate has given opinion that award of maintenance is on lower side and it's a fit case to prefer a revision petition in High Court.
Please, my lords. As far as the instruction, my lords, there are some health
What is
issues.
that? The advocate has given an opinion that award of maintenance is on the lower side and it's a fit case to prefer revision. Who is the petitioner?
I am the petitioner, my lords.
Wife or husband?
Wife is the petitioner in the bill of my lords. I am the husband, my lords, in the High Court. Please, my lords.
Correct. What is this affidavit you file?
Thereafter, the advocate has instructed me to secure the entire records from the lower courts, prefer a revision petition before the High Court.
No.
Please, my lords.
Paragraph number 5, last 2 lines.
Please, my lords. The local advocate took some time to go through the records and give the legal opinion. The advocate has given the opinion the award of maintenance is lower side.
No,
and
if
it
the
is
award of maintenance is on the lower side, why should you come to the court?
apology, my lords.
What is happening?
Apology, my lords.
Don't write that sentence. Record and to give legal opinion. In the meantime, he suffered from health issues and therefore unable to approach the advocate to prefer the petition. And upon recovering the health, from the health issues, he sought legal advice and initiated steps to file this petition. In the process, a delay of 907 days occurred. Then counsel for the petitioner submits that the petitioner was not represented. The order is passed within 2 months. As such, there is a delay. When an application is filed under Section 5 of the Limitation Act to condone the delay, and that too in the cases of inordinate delay of 3 days, the affidavit has to be specific, stating when, where, and how, and on what dates the things have happened. And each and every day's delay assumes significance in these kind of matters where there is inordinate delay. Unfortunately, nothing has been stated in the affidavit why he is coming before the court, not even except the impugned order date. No other date is mentioned, which clearly shows that there are no bona fides on the part of the client in coming to the court after a delay of 907 days. In that view of the matter, I number 1 of 25 to condone the delay of 907 days is dismissed. Consequently, RPFC is also dismissed.
Seal number 27. 27.
Yes.
Appear for respondent wife matters. Both the parties have settled the disputes before the Mangalore Mediation Center. Terms has been reduced matters and it is yet to be accepted by the trial court matters.
I have to seek instructions, my lords. Your lordships may kindly have it
tomorrow, my lord.
Then counsel for the respondent submits that already parties have entered into before the mediation center, they've entered into the compromise and they'll get specific instructions with regard to that. Does this matter when?
Any date, my lord, because they have to withdraw the petition for that purpose.
Any date, my lord, tomorrow.
Tomorrow,
Please.
does the matter tomorrow? Yes, 28.
Most good.
Number 28. 28.
Respondent in this case,
For
madam.
petitioner.
Kindly pass over, my
Nupama
lord.
Bodoli.
Pass over. Yes, next.
Cell number 29. Cell number 29.
For the respondent.
Pasha Rao.
Okay, for the petitioner, my lord. Handing over a check of rupees 1 lakh. Lordships may kindly see the earlier order, my lord.
According to the learned counsel appearing to the respondent, wife, the arrears are at rupees 1,52,000. According to the learned counsel appearing to the petitioner husband, the arrears are at rupees 1,04,000. The amount of arrears as submitted with the learned counsel husband shall be paid by the next date of hearing, or else the writ petition will not be heard by this court. And so the same shall be dismissed on that.
I paid 50,000 yesterday, my lord. Today I have paid rupees 1
Received
lakh.
amount, your lordships.
Today when the matter came up, learned counsel appearing for the petitioner submits that already an amount of rupees 50,000 is paid yesterday.
Yesterday, lordship.
And today by way of,
Check.
take the number, check number, by way of so-and-so, give it to the court officer. By way of so-and-so, check number drawn on the so-and-so bank with check number so-and-so. An amount of rupees 50,000 is given to the wife and the check is handed over to the learned counsel for the respondent. Learned counsel for the respondent also submits that 50,000 is given by way of cash. And what is directed to paid per month?
35,000.
20,000 as per the earlier order, my lord. Now there's a fresh order. Lordships may kindly recollect. There was an earlier order passed. This is the second round of writ petition, my lord, which is challenged.
No. In this order, what is the interim order?
35,000. your lordship.
35,000 is.
The petitioner shall continue to pay 35,000. Is this matter on?
I have one request, my lord, in this matter. It may be called out in the chambers. We'll explore any sort of possibilities.
Is there
Any day
any-
next week,
Any possibility?
Yeah, we'll have a discussion, your lordship. Yes, your lordship.
Ask her, otherwise why should we meet them in chamber?
Yes, your lordship.
Please for 1 lakh,
Yesterday 50,000 is paid. Today I've paid 1 lakh, my lord.
total 1,50,000.
Please, actually it's 1,04,000 according to my calculation. I didn't want it to, according to them, it's 1,56,000. I did not want it to hamper the proceedings. That's
But
the
he
reason.
paid 50,000 by cash, 1 lakh by check now.
50,000 by way of transfer, man.
50,000 by way of bank transfer.
Bank transfer.
And 1 lakh. check.
Yes, your lordship.
When?
Next week, any date maybe.
Let's this matter on 20th of August.
Great.
Yes, next.
In chamber.
In chambers at 2 o'clock.
Cell number 30.
For the petitioner's case, your lordships. I pray for a week's time in this case, your lordships.
Why? No.
No. The thing is that your lordship, I'm ready to pay the.
2024 matter.
No, the amount is
without even-
24,000 per month, your lordship. I'm ready to pay the half of the amount of this one, your lordship.
Why is it waiting?
Amount is granted is 24,000 per month, your lordships.
Why are you not pursuing the matter right from 2020?
Because your lordships.
Office objections, you don't comply.
We have completed,
Then
lordship.
when the court has specifically directed all the matters,
Some
then it is
documents,
complied.
because your lordship, some documents were missing. Now complete with your office objections, everything, your lordships.
Argue, let's see.
No, on the short date, next week, your lordship.
Why
Some
short?
papers are required, your lordship, because I find a conjugal rights before the Hubli, your lordship. That document is required
What does it matter?
because
Let's say you have filed, let us take it that you have filed a conjugal.
I'm ready to pay the half of the amount, your lordships.
What is the amount granted?
24,000 per month, your lordship. 24,000 per month.
25,000 per month.
Per
is
month.
Awarded. Pay 13,000.
Oblige, your lordship.
The agreed with order passed on I number 3 in criminal miscellaneous number 633 of 2023 dated 6 June 2024, whereby the court had granted maintenance of an amount of rupees 25,000. The husband is before this court. Then counsel submits that the amount that is granted by the court is on the higher side, and the same requires interference of this court. Without going into the merits of the matter, the husband is directed to pay an amount of rupees 13,000 per month by 5th of every succeeding month, and the arrears from the date of order till now at 13,000 shall be paid within 8 weeks from the date of receipt of the copy of the order, same default order. Next, the petitioner shall take out hand summons on the counsel appearing for the respondent and shall file a memo to that effect by 2nd of September.
To the court
Or
below,
else-
advocate. Your Lordship.
Advocate, or else hand summons on the counsel for the respondent before the trial court, or else a stay granted by this court stands vacated even on that count.
Oblige, Your
Yes.
Lordship.
Cell number 31 urgent, 32,
Yes.
32.
Yes.
Kindly grant stay for the inquest order passed by the trial court, Lordship. Because
Why
the
will
petitioner,
why will the court grant stay just like that?
Lordship.
Because your preferred writ petition stay has to be granted. Please come to the impugned order. Where is the impugned order?
Lordship, page number 35, there was an order passed by a trial court that the petitioner.
IA number 2 filed by the respondent under section 24 of the Indian Marriage Act is partly allowed. The husband is directed to pay monthly maintenance of 15,000 to the respondent.
But
it is.
But the petitioner is dismissed from the private limited company, so he can't able to pay 15,000 per month. Lordship.
How much he'll pay?
There is a final settlement of the company. He can able to pay 3 or 4,000 for a child. Lordship.
How can he pay 3 or 4,000?
Because Lordship, he is dismissed from the company, so he couldn't able to pay monthly 15,000. But he can pay. There is a settlement of 2,13,989. In that, he is going to give he is going to give 1 lakh rupees. So kindly please.
Get specific instructions from your client. How much monthly he is going to pay to the daughter. On that, we will grant stay. Come tomorrow.
Okay.
Yes, next.
Cell number 33.
For petitioner, my lords. My lords, in this case, I have furnished the copy of the petition, my lord. Only thing is I could not collect the hand summons, my lord. I have filed a memo to that effect that copy has been served on the counsel appearing before the trial court, my lords.
And how will the court know?
My lord, I have filed a memo to that effect, my lords.
Where is that? Where is
My
that?
lord, it was filed in the registry, my lords.
Look at it.
My lord, on 28th of July, I have filed, my lord, a memo.
20th of July, he filed a memo that he has served the counsel for the respondent. A memo is filed stating that already the notice is served on the counsel appearing with the respondent, Mr. K.S. Nagaraja. The notice to the respondent is well sufficient. Print the name of the counsel, Mr. K.S. Nagaraja, and list this matter on 3rd of September.
My lord, the interim order granted earlier may be extended.
Interim order earlier granted is extended till then. Yes.
Very grateful, my lords.
Omkar Basavaprabhu.
The petitioner in this matter, the petitioner and respondent are husband and wife, my lord. The husband, who is the petitioner herein, is aggrieved by the trial court's order, wherein an application filed under section 24 is allowed, and an interim maintenance of 15,000 per month is granted. That admitted on record, my lord, the respondent is an MBA graduate, and as on the date of filing of the interim application, my lord, she was in fact duly employed as admitted by her.
How much is earning?
My lord, she does not disclose how much she earns, but she admits to the fact that she is working as a professor, my lord. However, she contends.
How it was considered by the court?
My lord, the trial court gives a finding stating that simply because she makes a statement saying that it's not a permanent job and she's only a contractual worker, and that.
What is your income?
My lord, I have produced my income certificate, my lord. My client has an income of 99,000 per annum, my lord. That doc,
We will decide once the wife comes.
yes, income certificate is at page number
When
52.
counsel for the petitioner submits that, the court has not considered the fact that the wife is earning when she has admitted that she's working as a professor and granted 15,000 per month, which is on the higher side. The income of the husband is 99,000.
Yes, my lord.
99,000. This court will consider the other aspect with regard to the income of the wife. Once the respondent enters appearance, the petitioner, they shall be stay of all further proceedings on payment of 10,000.
My lord, kindly.
1 lakh you
Because,
have income.
1 lakh, my lord, per annum, my lord. Kindly, my lord, kindly, page number
They ask
52.
you what
may
is
be
your
perused.
income, you should tell what is the income of the month.
My lord, kindly, page number 52 may be perused. I have produced the income certificate itself, my lord. 1 lakh, my lord, per annum is his income. And in addition to this, my lord, kindly annexure K may be perused.
Page number.
Where, my lord, page number 52, this honorable court will find the income certificate of the respondent. It is of the year 2023, my lord.
Where is it? How much is the latest one?
My lord, this certificate is valid for 5 years, as stated in the certificate itself.
Where are you working?
My lord, he gets some rental income, my lord. Per se, he is not employed. He is left behind
You
some
have to
inheritance.
depend upon this certificate issued by the tehsildar.
Yes, my lord. Other than that, my lord, at annexure G.
Now please come to the order. Let's see
Yeah.
how the court has dealt with it.
My lord, annexure A. My lord, the trial court simply, my lord, states that there is the factum of the marriage is admitted between the parties. Kindly, page number 28, my lord. There's no reasoning as to the income or otherwise. My lord, admittedly, kindly, page number.
What is your qualification?
My lord, he is a BCom graduate. My lord, kindly, page number 34 may be perused, my lord.
No, you are not doing anything.
No, as on today, no, my lord. He had some business. However, he suffered huge losses, which has led to closure of the business. So, as on today, my lord, from annexure K, I have produced from annexure H, from annexure K and onwards. My lord, I have produced the
On payment of 5,000 and arrears at 5,000. They shall be stay of all further proceedings, and you shall take out hand summons list. You shall take out hand summons on the counsel appearing to respond. You shall file a memo to that effect by like in the other case, same date. Yes, next.
Still number 35.
I'm grateful.
Arrears also at within 8 weeks. At 5,000.
Srinivasan K, 35.
His income is 1 lakh per annum, and she is MBA graduate. Yes.
The writ petition is filed challenging the order dated 23/2025 passed by the second additional family court in IA number 7 in OS 315 of 2021,
Where is
which
the
is
impugned order?
annexure. My lord,
Where is the impugned order? Page number.
annexure A, page 21, my lord.
What is granted
By the said order, the family court has directed me to produce the extensive financial documents, including the foreign bank statements and US tax returns, my lord, dating back to 2010. My lord, the suit itself, that is OS 315 of 2025 itself, is not maintainable because it is for recovery. This petitioner is the wife of the respondent. The respondent has filed the suit for recovery of the alleged monies of 20 lakhs spent by him on the wife and
No, we
children.
will not, in this writ petition, we will not go into the maintainability of the suit.
My lord,
So what is the order? Suit is for recovery of the amount from the defendant, also for damages of 5 lakhs.
yes, my lord.
And plaintiff has also sought to return the gold which are alleged in the custody of the defendant.
Yes, my lord. So the suit itself is not maintainable because
that you cannot argue now, because that is not the IA.
The interim prayer we have sought for staying the further proceedings because the documents are not in exclusive custody of the petitioners, my lord. The US banks have been closed in the year 2015 and 16 itself.
That you should have informed to the court.
We had got only one date as for filing our objections. Immediately after that, they had taken our objections as nil, and they have not considered our detailed written statement, wherein in our written statement, which is at annexure D, I would like to draw your attention at annexure D, para 39, my lord.
Don't expect that now the family courts will grant 1, 2, 3, 4 running into 20 adjournments. They will give you a one adjournment. You don't do it, they will pass orders.
My
And
lord-
further, the court will not interfere.
My lord, written statement, we had clearly mentioned that we
Court will not see a written statement when an IA is filed for a particular purpose. You have to file objections to the IA, or else you should say,
yes,
whatever your contention in so and so written statement, that may be read as your objection. Then
yes,
we
my
can
lord.
understand.
We were, since there were 3 cases, my lord. There are 3-4 pending cases where the petitioner had filed the DV case against the respondent. In retaliation, the respondent filed MC case for restitution as.
At best will order notice, no interim order.
My lord, stay the further proceedings, my lord. Kindly.
Notice to the
because-
respondent.
My lord, there are 4-5
Permitted to
pending
take
cases
out
before the trial court, my lord. Same court.
Shall take out hand summons on the counsel appearing for the respondent and file a memo to that effect. List this matter on 28th of August, if the memo is filed. Yes, next.
36 for admission,
Yes,
Nagaraj Hegde.
yes, 36. What is this?
PB Raju.
Appellant, my lord,
We have
kindly
filed.
pass over the matter, my lord.
Challenge the quantum, my lord. Matter may be referred to Lok Adalat also, my lord.
Kindly pass over the matter, my lord.
Pass over.
Serial number 37. Srinivasa in MY.
Case of death. We'll deal it after. 2:30 will call.
Yes,
Huh?
please. We already discussed.
2:30. 2:30. Yes. Let's see any other matter which can be adjourned.
Serial
38.
number 38. Serial number 38.
Appearing for petitioner, my lordship, the parties have been settled before the family. Like we'll produce the documents on the next date of hearing any short.
You have not paid the maintenance as ordered on 9/1/2023, my lord.
No,
The matter has been settled, my lord.
He's saying about settlement. Find out from your client. Learn counsel for the petition submitted. The matter is settled. Learn counsel for the respondent. Seeks time to get instructions. Let this matter on 3rd of September.
Serial number
Yes.
39. Somshekar Angade. 39.
Pass over. Next 40.
Serial number 40. Kumbigi.
I have filed my lord's assets and liability of the petitioner herein.
Hmm.
Sir, 7,500 each, my lord.
Why it says non-filing of assets and liabilities? As per the cause list, is it filed?
Lord, sir, I will verify, my lord. Sir. I sent it last week.
Because it
itself.
shows, cause list shows non-filing.
Kindly have it, my lord, next week.
This is matter finally on 9th. By the time the statement of assets and liabilities shall be on record, or else the petition will be dismissed on the ground 41.
41 urgent. 42 urgent. Serial number 43. 43. Venkatesh C for petitioner. Mahendra Gowda.
42 and for respondent.
42 is
What for
urgent.
time? In the morning. They said, they must have said they have informed also. Yes, 43.
43.
Huh.
Kindly place time.
Why?
Agreed to withdraw the case.
You want to withdraw? Today?
No, my lord, next.
We'll have it tomorrow then. You want to withdraw? Tomorrow. It is submitted that the petitioner wants to withdraw the petition. Is 44?
44. 44.
For the
Srinivasa
respondent,
K.
my lord, may be passed over.
Yes, pass over.
Serial number
45.
45. Basavaraj Patel.
Pass over? Yes, 46.
Tomorrow it may be called, my lord, that time tomorrow.
Difficulty is every day 70, 80 matters.
Please, please.
Pass over. Yes, 48.
Number 46. Raghu Prasad BS. 46. Raghu Prasad.
Pass over.
Serial number 47. Urgent. 48. Venkat Reddy CM.
Yes, pass over.
49. DJ Sunkapur.
On record counseling feeling not well, my lord, today. Kindly short accommodation, please.
List the matter on 3rd of
Interim order action, please.
3rd of September. Interim order earlier granted is extended till then. At the request of learned counsel, the petition that is not filed. Yes, 50.
50. Dina Bandhu.
Huh? You appear for the petition or respondent?
Respondent.
Huh? They have interim order?
There is no interim order.
We don't know. We'll do it in their presence. We'll be there in the afternoon. Yes, 51.
51. Suresh Subrai.
The date might be given, my lord. The date might be given.
Why?
My lord, there's some inconvenience today, so kindly have it tomorrow, my lord.
You have an interim order in your favor?
Interim order may kindly be extended.
You have an interim
Yes,
order?
yes, I have
This
interim.
matter on September 16th. Interim order earlier granted at the request of learned counsel for the respondent, and interim order earlier granted is extended till then. Yes.
Cell number
16-9, madam. 16-9.
69.
Yes.
52, P. Nataraj.
Passover.
Cell number 53, urgent. 54, Mahesh BJ.
I am for the respondent in 54, and they have not compiled this honorable court order, my lord.
Come at the afternoon. Yes.
Cell number 55, urgent. 56, final hearing MFA.
Yes, yes. Afternoon.
Yes, Your Lordship.
There should be mentioned in chamber matters will be taken at 5 o'clock.
Yes.
5 o'clock. Grateful. Thank you.
Madam, serial number 19. Serial number 19. Madam, 3 are there.
37. One ನಿಮಿಷ ಸರ್.
Okay.
36 ಪಾಸ್ ಓವರ್. 37 ಪಾಸ್ ಓವರ್. ಆಮೇಲೆ 38 39 49 39 39 ಪಾಸ್ ಓವರ್. ಒಂದು ನಿಮಿಷ 39
ಇಲ್ಲಿದೆ ನೋಡಿ
39 ಪಾಸ್
40 ಆಗೋಗಿದೆ
40 ಆಗೋಗಿದೆ 40
41 ಅವ್ರಿಗೆ ಆಗಿದೆ ಬಿಡಿ
41 and 42
ಆಯ್ತು
40
43 ಕೊಟ್ಟೆ ಬಿಡಿ ಡೇಟ್ ನಾನು ಅವ್ರಿಗೆ ಕೊಟ್ಟೆ 46 48 ಪಾಸ್ ಓವರ್ ಕೊಡಿ ಕೊಡಿ 52 53 ಮುಂಚೆನೇ ಆಗೋಗಿದೆ 55 ಮುಂಚೆನೇ ಆಗೋಗಿದೆ ಅಷ್ಟೇ ಅಲ್ಲಿಗೆ ನಿಲ್ತು ಹೌದು ಇಷ್ಟೇ ನಿಮ್ಗೆ ಆಯ್ತಾ ಇದೊಂದು ಇದೇನಾಯ್ತು 35
ಅವರಿಗೆ PH
ಹೌದು 35 ಆಗಿದೆ ಅಲ್ವಾ
35 ಆಗಿದೆ
ತಗೊಳ್ಳಿ
35 28 ಸರ್ ಏನ್ ಬೇಕೇಳಿ 19 ಅದೇ ಆಗಿದೆ ಆರ್ಡರ್ ಹಾ ಫಾರ್ಟಿ ನೈನ್ 3/9 ಹೋಗಿದೆ 46 ಇದೆ ಮೇಡಮ್ 3 ಆಯ್ತಾಯ್ತು ಸೇಮ್ ಸಂಡೇ ಆಯ್ತಾಯ್ತು ಹಾ ಗೊತ್ತಿಲ್ಲ ಇವ್ರೆ 4 o'clock ರೆಫರೆನ್ಸ್ ಇದೆ Pass over matter, CL number 28. Gautam Raghunath for petitioner. Anpurna Bardoli.
I appear for the petitioner in this matter, my lords.
Yes, what happened?
Well, it's pursuant to the order of this honorable court. We have taken both the children to the mother's place. The younger one started crying. He was very scared, anxious to go to mother's house.
Why?
That's why we wanted to have a interaction, because then the elder brother was also there. Father along took the elder son. Elder son stayed. Elder son stayed.
Stayed
but
back in the night?
He stayed that night.
Yes.
The younger one refused. The moment he entered, he started crying, howling, and he was under so much pressure that he has to stay overnight. We have got them to a stage after so much of trauma, what they have gone through. Now, my lords, what happens is, if the court says that compulsorily you have to stay, they told they like their mother, which is a good thing. But at the same time, if that pressure comes in their head, I don't know. Today also, the younger one did not go to school. The elder one stayed and he came back at 10:30. But the younger one refused to stay. He cried inconsolably for.
It's okay if he is not interested. You should have taken him. What is?
We took him.
Why to? There is nothing. No, we will make them understand it slowly. Now the elder one is comfortable.
Yes,
He stayed
we
back.
convince.
Younger one also in due process, in due course, he will stay.
No, the point is, my lords, if we put a pressure that you have to stay, when usually they go at 3 o'clock as per the earlier order, if the child wants to stay back, we have no difficulty, because the caretaker will be there. We have stationed him there. There is no difficulty. But if we put them a pressure that you have to stay, they get little anxious. Now the elder one knew that he has a choice. He can stay, he may not stay. So he took a choice, he stayed back. We have no difficulty. Father went 3 to 4 times to make him feel comfortable, saying that don't worry, you are safe. I am nearby only. I'll come back. He was safe. He stayed and he came. But if there is a pressure that you compulsorily have to stay, then that's when the problem is. Otherwise, my lords.
Yes, Mr. Gautam.
My lords has interacted with both the children. The younger one was more happy to stay with the mother, if my lords could recall that day. And my lords, all of a sudden, a new story is being cooked up wherein suddenly the younger one does not.
What has transpired on the day? Do you deny the fact that the elder one is not crying?
The elder one was absolutely comfortable. The younger one was crying. Younger one was crying. We do not know as to why. But it's because every time the younger one would stay back and the elder one would come back, go back to the father. This time when he was brought to the house, he was crying. But we don't know what's transpired before them bringing to the house. So, my lords, even I was in fact surprised with the fact as to why did the younger one cry. The moment I have the video, I can show it to my lords.
He's a small child. He has his own reasons. We can't have any on that specific analysis on why he is doing it. He was not comfortable. He was crying. He was comfortable. He's staying. Elder one never thought that he would stay back. He stayed back. So the more easy to tutor is the elder one. If at all, what if I have to take it the submissions away, then he is able to stay. That means we have to take it that there is no tutoring. Younger one, they're all the children. They have their own emotions. They have their own mood swings and all. They do whatever.
My lords, may I request, please, my lords, to my surprise, to my utter dismay. In fact, I could not believe that the younger one did not want to come, my lords. But I have the videos. I could play it before your lordships. Nonetheless, my lords, the same could be tried again this Saturday, and we'll see if the younger one wants to go there or not.
No,
because
is like that.
The elder one is happy.
They will come. They will come. If the boy says he wants to stay back, let him stay back. If he says he wants to go back, let him go back.
Yes,
but let them not.
We will cooperate.
One second, ma'am. Let them not be, my lords. My lords, like I say, my lords, when my learned friend says he's been under the pressure, I can also make the same submission stating that he's been under the pressure of the father. But I will in fact, I will not make that submission, my lords. But this Saturday, let us see, my lords, as to how it transpires, my lords. Let the father persuade them The mother, in fact, I've seen the
He
videos.
must have, he must have
Due to my
persuaded.
discussion, I could not be there
He
present.
must have persuaded. Otherwise, the elder one wouldn't have.
Absolutely,
back.
my lord. We definitely concede to that. But the elder one was absolutely fine, I believe. It was the younger one this time, my lords. Unfortunately, it's.
We'll see. We'll see. No, let's not drag anybody in between. We'll only try to let your client I mean develop that rapport with the children. Let's also not pressurize the children. Let's just see how it works out.
Let the
So
children
what
not
to
be
do
informed
is-
that they would have to stay overnight, my lords, because what happens is if they say
No,
that is the reason, let the children just go there and, my lords,
No,
if they
the
want to
same
stay, let them stay.
the same order like how it
Yes.
is passed this
Please.
week also,
Yes.
basing on the like how comfortable the children are. No,
Please.
under these circumstances, the one has already like straight away has come and stayed.
Yes, Manoj.
Yes.
Has he any complaints after coming back? He has.
When I was there, I had to visit 3-4 times over there to, satisfy him, tell him that don't be worried, I'm here.
So please tell him
So-
again and let it go on. One Saturday, another some more.
Please.
After 1 or 2 times, they also get used to it because there's a gap in between.
Please.
So this arrangement, what I am referring to, maybe at this point of time you won't be understanding.
I
But
understand.
it is also in your interest also.
Yes, my lords, I understood the moment my lords have passed that order. That's why I am very grateful that this arrangement is made. But subject to the condition that they should not, because they are.
Ultimately, it's the welfare of the child.
Yes.
That is what matters to the court.
Yes, my lord.
So we will
Yes.
take it slowly.
Yes.
And let both sides have the patience.
Yes.
Cooperate with each
Yes.
other in reaching this goal.
Yes, my lords, absolutely.
This
So-
court on 4/8/2025 has passed an order where on the Saturday, both the children along with the caretaker shall be directed that both the children along with the caretaker shall reach the mother's place by 3 p.m. And on next day, that is Sunday, they can take back the father can take back the children by 11 a.m. And it is also observed that if the elder son is not showing any interest for the overnight stay, the father shall convince the elder son to stay back, or at least the younger son shall be with the mother overnight. During the overnight stay of the children, the caretaker can be there along with the children. But today, when the matter came up, both the father and mother were before the court, and learned counsel appearing for the father submits that in fact, the elder one had stayed with the mother, but younger one was not at all interested for an overnight stay, and as he was continuously crying, yelling. That made the father to get the boy back. And as far as elder one is concerned, the father has encouraged him to stay back. In fact, in between 3-4 times, the father had gone to the place and convinced the elder one to stay back. Learned counsel submits that for the father submits that they have no problem in the children if the children are interested to stay back overnight, but if they're compulsorily made to stay back, that's where the children are not comfortable. Next para, learn counsel appearing for the mother does not dispute the fact that the elder one stayed back and the younger one showed the reluctance. However, learned counsel submits that why the younger one was like that, as earlier he was very comfortable with the mother, is not known. It is submitted that if the arrangement is continued, it would facilitate the mother to have the visitation. Next para. Having heard the counsels on either side, having regard to the fact that the elder one stayed back and younger one, as it is for the first time, is coming back to stay overnight with the mother. He might be, he might be, he was not comfortable that day. However, as the elder one is staying, and if this is taken slowly, and once the children slowly get used to the mother, and once they start feeling comfortable, the court can pass further orders. In the light of the above, this court is passing the following order. On the coming Saturday, that's on
16th, my lords.
16th, both the children shall go to along with the caretaker, shall go to the mother's place by 3 p.m. And next day, the father can take the children back by 11 a.m. If if any of them are not comfortable and they do not want to stay back, the mother can send the child along with the caretaker to the father. In that case, if they fail to stay overnight with the father, the mother shall have the visitation for some more hours on the next day.
Yes.
At least for 3 hours on the next day, comfortable
Please.
to the children.
Great.
My lords, subject to the children's requirement, my lords, we can't force them. That's what we are finding difficult. If there is, my lords, what happens 3 o'clock, let the children go, let them spend time.
I said
No,
in
my lords,
order.
again, compulsory Sunday,
What compulsory Sunday?
that compulsory, again, they are.
It is like now the children rights have come in. Now we are not looking at we are only looking at their welfare.
Yes, my
They're
lords,
not on the
but
rights.
Sunday he likes to spend time with the children.
What is happening? Because 3 o'clock, earlier arrangement was 10 o'clock. You remember that? Now we are
Correct.
making it from 10 o'clock. Now the children they don't want to stay back. They will go by 6 o'clock.
Yes, my lord.
But then,
3 to 9.
but don't take advantage of this fact.
My lords,
that the
not,
hotel
we are not, my lords, we are agreeing.
such an order, and don't tell the children that they can come back home by 9 o'clock.
Yes.
No, my lords, we have been cooperating with everything. We ourselves have been convincing the child to go and stay with the mother. If we put a pressure that taking that time frame, we are happy to send them if they want to go
Where
again.
is the time frame? I said whenever they're not comfortable, they can
That
come
is
back.
fine, my lords. Sunday again is a difficult
They are
time.
not staying back, if they are not spending time, because as you say that whenever, like now, if I pass an order, if that is as per their convenience, they should come and go. They will come and they go. That's how it won't work out like that.
My lords, we have no intention to keep them at home and not send it to the
What
mother.
about the intentions? Ultimately, what is the ultimate result is what matters.
Yes.
My lords, it's about the hours.
Maybe
That's
you
what
have
I'm
good
saying. My
intentions,
lords, the
but it should also, culminate into some practical this thing.
My lords, we all are mothers, so we know how things work. But the point is here in
There is a mother. You also have to think about
yes,
the
yes, my
mother.
lords, absolutely. That is the reason.
My lords, may I have this on 20th, my lords, if you may request?
Huh?
20th of August, my lords.
You can tell your client also, your advocate also. What is that?
Yeah, he's informed about.
What is that she's saying?
My lords, what the petitioner intends to state is that the younger child who has been coming all this while suddenly does not want to come is because of the influence of the stepmother as well. Which, my lords, that is the issue that's coming up every
So
time.
then we have to presume that what your clients earlier submitting is not correct. She says that the
The elder one was fine, my lords.
stepmother is not taking care of him properly. If she is not taking care of him properly, why would he listen to her?
No, my lords. What she tries to, in fact, what she's trying to state is that, my lords, the harassment that the children are undergoing. I've advised her, let this continue and let this go. How, anyways, let us see how this.
Problem is, mother's perspective is harassment by the
No, my
stepmother.
lords, there is an entire video which I would want to show it to your
Father's
lordship.
perspective is mother's.
Yes, I understand, my lords. Yes.
Yes.
My lords, 20th August, if I may request, my lords.
Yes, that's the matter on 20th August. Please.
Great.
Yes, next.
Cell number 36. Cell number 36.
Yes.
Nagaraj Agde for appellant PB Raju.
What is this?
My case, my lord, is for enhancement. The claim petition under the Employees
You are
Compensation
questioning
Act.
on what ground? Yes, Mr.
My lord,
Appeal is on what ground?
appeal is on quantum, my lord.
Phantom only. Please come to the.
Other ground we have raised, my lord, regarding a relationship between employer and employee. That may not serve. Please.
Formal ground.
Please be.
Please come to the calculation.
Lord, 12,000 has been taken as a salary, monthly salary of the deceased.
There is evidence?
Pardon, madam? We have produced the document, but the salary certificate also been produced, and author of the document has also been examined as PW2. According to the said document mode, he is getting more than 12,000, but the tribunal commissioner has taken 12,000.
What do you say on that?
My lord, as per EC Act, my lord, in the year 2016, the sale was 8,000. Whatever the excess amount, let the employer may pay, my lord. That is our contention.
No, what is the law on that? When there is no evidence, it is 8,000. Wherever there is evidence, also it is 8,000.
My lord.
Minimum, as per the notification, the wages are 8,000.
8,000.
No, when there is evidence that he is paid more than that,
But that's what.
give that. Yeah, EC Act. Section 4.
Section
4.
1B.
1B, my lord.
1A.
1A. 1A.
And 1B. One B, my lord, says, my lord, it is notification has
Case
to
of
be.
injury.
Yes, ma'am. Death.
Death case, ma'am.
The case of death.
Where death results from the injury. Where permanent. So we have to see 4A. It says an amount equal to 50% of the monthly wages.
That is deduction, ma'am.
No, that is deduction. So where is monthly wages? That provided that the central government time to time enhance the amount of compensation mentioned in clause A and B. What is the 60? This 1B? 1B.
1B, my lord, that is what, my lord. The central government may, by notification in official gazette, specify for the purpose of subsection 1 such monthly wages in relation to the employees as it may consider necessary. But the notification is of the year 2011, specifying, my lord, 8,000 per month. What is the accident, my lord, which has been took place in the year 2016, my lord.
So like time to time they are giving the notification.
They are not enhanced the amount.
There is,
that is what
even till now that is 8,000.
2021, my lord.
Subsequently, it has amended, my lord.
When?
Again, now it's
In the year
2021.
2021. 21. After
15,000, my lord.
10,000.
Then there is, if they prove the income, then they can the income may be considered higher also, my lord. In 2021, my lord. Up to then, it was 8,000.
After 10 years, my lord, 8,000 has been enhanced in the year 2021. In between, no enhancement.
Are we bound by that or not? Notification.
No, as per this, my lord, it has to be enhanced, taking into consideration of the section.
Here's a simple question. The income, are we going by the notification? Like in case of motor vehicles accident,
yes, ma'am.
are we going with under the MV Act?
My lord,
are we going on the basing on the evidence or basing on the notification?
Kindly have it, my lord. I'll get one judgment, my lord, this honorable court.
Yes. Tomorrow. Not tomorrow. This
Next
is
week.
matter on next Monday.
Please, ma'am.
Yes, next.
Monday, instead of Monday, my lord, Tuesday.
Tuesday, at the request of Lord Counsel for the appellant.
Obliged.
Number
37. What is that you have arrived at?
Income is taken at 16,000 and on that basis.
How can it be?
My lord, the 2020
So
accident.
did he accept?
My lord?
Did he accept?
No. Yesterday we are.
Sri Kumar?
Please, my lord.
How
My
can
lord.
it be? No. Morning you were telling that we have already we had a discussion. I didn't see that you are appearing. How did you accept?
My lord, I accept means because kindly see agreed P 10 and 11 and 12.
But even for acceptable things also there should be some argument.
No.
So, which year is accident?
My lord, 2020 accident, my lord. I don't know. This is
That's
bachelor's.
what,
How much is taken by the court?
14,500 was taken.
that is correct if they take the notional income.
This my lord aged 19 years, student and my lord,
One minute. 2020 it is 14,500.
Yes, that is
In
correct.
this case, my lord aged 19 years. So he is a my lord student, first year BSc, BCA student, and also my lord loader and unloader. That's why my lord we increased my lord 14,500 to 16,000. Income was
We are increasing it basing on his qualification.
qualification. I have produced my lord exhibit the mass card of my lord first BCA. He was a student.
Even the degree, this thing also, in some of the judgments, Supreme Court said it's only 15,000.
No, my lord. Is even my lord after finishing degree, my lord engineering student, my lord
He's not an
19,000.
engineering student.
Please, ma'am.
He's a BCom. We said BSc or BCom.
BCA, first year BCA.
Hmm.
Yes, ma'am. That's why we stood together, my lord, and taken my lord, another 1,500.
It's not about both of you taking. It is about what is the law on that.
Law, my lord, in this case, we have not proved, my lord.
Because in all these student cases, one of the case like I saw recently some 15,000 was taken.
But my lord, he suppose he is
Unloaded, no. How a
suppose
student
he
is
is engineering.
expected to.
Allah. Suppose he is an engineering student, my lord, Supreme Court was, my lord, taken 20,000 per month income.
He's not engineering student.
Not
Engineering
but,
student, after
studying.
Engineering student for them.
But my lord, he is still my lord studying. After finishing, my lord, he will my lord, take good job in future, my lord. He's the only dependent.
So that's what I'm saying. Let us. What happens is, in one case you take this, one case you take the other one. Unnecessarily it gives it complicates. No, nobody like whatever is in favor of you, you will cite this judgment. What is in his favor, you will cite that judgment.
Please.
So ultimately, litigant is in a complete
Yes.
state of chaos.
Please.
So let us basing on some law. What is that we are taking in respect of a BCA or it's a normal degree
Yes,
student.
He is the
Second
student.
year
Student
degree
of first
student.
year, Yes.
I think 15 should do.
Already 14,500 taken.
Another 500.
The dependent, fully depending upon the my lord, in future, my lord, after my lord getting age, father is only dependent. So aged person.
So that's why I'm saying I'm inclined to take 15.
My lord,
If you
even
say
otherwise, my lord, some
16 has to be taken. You show me some law on that. Like in
There
this
is no-
particular judgment.
But regarding 16,000, there is no law, ma'am.
That's why we have to take 15.
15, my lord, is a very.
If he wants to take it as 16, I'll record that Mr. Vijay Kumar wants it.
no, I cannot concede, my lord. But I have got whether other grounds also what your lordship is just and reasonable. Even otherwise, it is not enhanceable also. But anyway, I leave to your lordship. Make it 15 and close it.
1,500 extra. Only taken 1,500 extra, my lord. 14,500 is the notional.
What? We will take 20,000 also, provided law permits.
Law regarding.
Because here it is, courts are not giving or judges are not granting compensation from their
Pocket.
salary. We are basing on a settled law. We have to do it. Then only it's good for everyone. We can't show unnecessary, sympathies on something which is based on law. Should be based on law. If you say he is entitled for 20,000, this is a Supreme Court, I will take it 20,000.
And
As far as the judgments I have seen, 50,000 appears to be the compensation. If you want also, I can give you time to find out 16,000.
ಆಯ್ತು ಬಿಡಿ ಬೇಡ ಬಿಡಿ ಮಾಡ್ಲಿ ಬಿಡಿ
Is 1,000 my lord, extra 1,000. 1,000.
your last might take 15,000 and do it, my lord.
1,000. 15,500. 1,000 extra, my lord.
If it is 15,000, why not 16,000? That's why I'm saying, if you want, I can grant time, or else I can make calculation.
Regarding income, my lord, I don't have. My lord.
Because it won't be, there won't be anything.
Srinivas.
We cannot
Leave it
know.
to-
This
Srinivas,
order
very
I
astute.
pass, it becomes a precedent now.
Definitely,
With the lordship.
definitely.
So 15,000 plus 40% future prospects.
6,000, 21,000, 10,500.
21,000. Half has to be reduced.
50%. 50%.
11,000. 11,000?
Bachelor.
Alla, 21,000, 10,500.
10,500.
10,500.
Into 12 into 18.
Yes.
It comes to 22 lakhs, who are the claimants?
Only the father.
On father,
Only the father.
Father and mother.
No, not mother.
not mother.
Only,
Don't have-
only father.
Only father.
Then 44,000, 36,000.
That is already given, my lord. That is correct. Only loss of dependency I have seen.
That is the only.
How much was given?
21 lakh 92,400.
21 lakhs, 92,400.
400.
Now it comes to 23 lakhs, 58,000. Please come. Agreed with award passed. MBC number 1039 of 2020 dated 26 April 2023, whereby the court had granted compensation of an amount of rupees 22 lakhs 69,000, not 92,000.
Total, my lord. Total amount.
22 lakh 69,000 total.
22 lakhs 69,000.
69,400.
400. The claimant is before this court. The claim petition is filed seeking compensation of an amount of rupees 34 lakhs 70,000 for the death of the deceased in the accident. The deceased was a BCA second year student. According to the claimants, he was studying and also working as a loader and unloader and earning how much? Earning how much?
20,000.
Earning 20,000 per month. The tribunal, considering the fact that he is a student and as there is no evidence that he is doing any other work, the tribunal has taken 14,500 as the income and granted the compensation. Then counsel appearing for the petitioner claimant submits that the court without any basis had the court ought to have taken the income at 16,000 per month. It is submitted that as he is a BCA student, as he has a good prospects in life, the court ought to have taken the income at 16,000. And it is submitted that the compensation needs to be enhanced. Next parallel and counsel appearing for the respondent insurance company submits that the court has rightly taken as for the notional income of the year 2020 and no enhancement is required. Next para. Having heard the counsels on either side, there is a material on record. The claimant, the deceased, is pursuing his BCA second year in the light of the settled law and also in cases where Honorable Apex Court has taken the income of engineering student at 15,000. This court is inclined to take the income at 15,000. Future prospects at 40,000, 40% comes to 6,000 and the income is 21,000. As he is a bachelor, 50% has to be deducted towards the personal expenses. It comes to 10,500 into 12 into 18 is 22,68,000. Consortium 44,000. Funeral expenses 36,000. And in the light of the law laid down in make allowance towards litigation expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 23 lakhs 58,000. Accordingly, the appeal is partly allowed, enhancing the compensation from 21 lakhs 69,400 to 23 lakhs 58,000. Yes, next.
Cell number 39. 39.
Yes, appear for petitioner, Your Honor. Your Lordship kindly see.
Which one?
The letter sent by.
What is the report from the judge? Report received from the principal judge, Family Court, Tumkur. What is the report? You have asked for, no, you have not asked for stay of all further proceedings. What is asked is stay the order of IA number so and so.
Yes.
Then by the further proceedings will be stayed. You are submitting the other day, though there is an order of stay of further proceedings, court has conducted.
Your Lordship, I asked only the particular order of stay.
Then what was the complaint you were making on the last occasion?
I have not made.
So you said so.
I have
When there is a
asked,
stay from
what
this
is
court.
your prayer? I told only particular that order dated so and so, it is stay. It
I'll
continues.
record your submission. I'll record your submission from the order.
It
Please,
is-
please look at the order passed by this court. Learned counsel for the petitioner submits that the order by this court is placed before the principal judge family court. The family court had proceeded with the matter and dispose of the matter when there is a stay by this court. That's what you have submitted.
When there is a stay, not further proceedings, I have not sought for. Only order of the particular date.
So now nothing remains in this now. Please come. The learned counsel appearing for the petitioner
Communicated to the
on the
trial
last
court.
occasion submitted that in spite of an order passed by this court, the court had proceeded with the matter and disposed of the matter. And basing on the said submission, this court has called for a report from the judge. The family court judge has placed the order before the court stating that the court has not granted further proceedings, but only the order, that particular order is stayed. Learned counsel also does not dispute the fact, but unfortunately, on the last occasion, he was very vehemently arguing that when an order is there by this court, how can the court dispose of the matter? And it is a clear violation of the orders passed by this court. And now, after the report is received, the submission of the counsel is altogether different. In the light of the fact, already the RPFC is disposed of, the main petition itself is disposed of. Nothing survives for consideration this petition. Accordingly dismissed.
Number 44. 44, Srinivasa K for petitioner.
Respondent 5.
Yes. Where is the
In spite
petitioner?
of the order of this honorable court to pay a maintenance of 10,000 rupees per month without fail. Till now, 2,60,000 is pending, my lord. If I may draw your lordship's attention to the order dated
When was the
28/11,
order of this court?
28/11/2022, my lord.
28,
11/2022, my lord.
28/11.
20,000 was awarded to,
Wait 1 minute,
please.
let me look at the order. 10,000 per month is the order of this court.
Please, my lord. 20,000 was awarded in the family court. Till the disposal of this petition, continue to pay 10,000. That was the order. My lord, 2022 to 25, even if you take it at for 3 years, 3,60,000, what is pending is 2,60,000. If I may read this order, my lord, for 1 second.
It is submitted that as per the order dated 28/11/2022, petition is directed to pay an amount of rupees 10,000 per month and to clear all the arrears till date by the next date of hearing. And that order is from time to time, that order is extended. Today, when the matter is called, there is no representation on behalf of the petitioner. Learned counsel appearing for the respondent submits that the order of this court is only partly complied and that there are arrears running to a tune of rupees
60,000, my lord.
2,60,000, considering the fact that the order dated 28/11/2022 is not complete fully. The order is vacated. The order is vacated. Yes, the petition is at liberty to execute the order. List this matter on 10th of September. Yes.
Till number 45.
For the petitioner.
I'm the respondent in this case, ma'am.
This is with regard to the interim maintenance. The main
Ready?
petition is pending.
Ready, my lord.
Main petition is pending. I will get the status of the main petition and I can address my argument.
Which year is MC?
It is in
22, my lord.
Miscellaneous 125 proceedings, my lord. That
Oh, in
seems
miscellaneous proceedings.
54 of 22.
54 of 2022, my lord.
That we will stay.
Now-
Get the stage.
Tomorrow is stage is argument, my lord.
Then we will.
No, what I'll say is.
Please.
Like any of the matter has come up to the arguments without passing any order on the merits of it, let the court decide that.
Let the court decides on the merits. my lord,
That's it. The present petition is fine.
My lord, one more submission, my lord.
Expecting an order. Yes.
Remaining maintenance is not paid, my lord. 2,80,000
It is,
2,80,000 is balance, my
my
lord. Is
So what happens is, ultimately, even if this petition is dismissed, you have to execute the order and get the maintenance. So now if this petition, the interim order goes, you are at liberty.
But there is no
Petitioner is a-
interim order here,
Huh.
that the salary is attached, according to my information. That
No
the,
interim order here.
no
Huh.
interim order.
interim order.
Agreed with orders passed in criminal IA number. What is the IA number?
The IA number.
Supreme.
On an
Not,
interim
the
application
orders
for
on interim
maintenance.
application, it's-
Interim application for maintenance, the family court has passed an order granting 10,000 maintenance to the wife. Agreed thereby, the husband is before this court. When the matter came up, when counsel for the respondent submits that the matter is posted for arguments and it's coming up tomorrow. This is a writ petition of 2023 and the order is passed on 1/7/2023. Considering the fact that the matter is coming up for the arguments at this stage, this court is not inclined to interfere with this writ petition. Accordingly, the writ petition is disposed of, leaving it open to the parties to raise their respective contingents before the trial court.
Obliged.
Time may be fixed, my lord. Otherwise, is dragging the proceedings, my lord. Trial court.
It is not your repetition.
Oh, my lord.
Yes, next.
Stage is arguments, my lord. His
Let it
intention
continue.
is
Why
not-
should the court there be a direction from this court?
is not paid the arrears also, my lord. That's why I'm humble.
Yes,
sir.
next.
Still number 46, Raghu Prasad BS for petitioner, RB Sabha.
50? 40?
6.
Huh.
Appear for the petitioner, my lord.
Where is the other side? Any urgency for you?
No.
You
There
have a
is-
stay?
There is a stay.
No representation for the respondent. List is matter on 13th of October. Interim order earlier granted is extended till then. Next.
Obliged.
Number 47 and then 48, Venkat Reddy CM.
Respondent in this case, Lords. Lords, there's a deposit which is made in pursuance of the order of this honorable court, Lords. What they have,
As per this honorable court, my lord, 50%.
my Lords, my request now is, my Lords, the respondent wife may kindly be permitted to withdraw that, my Lords, because
No objection.
As per the order passed by this court, the petition has deposited the amount and the respondent wife is at liberty to withdraw the same.
Please.
List is matter on 16th of September.
Please.
Yes, next.
Still number 49 and then 50. Still number 50, Dina Bandhu Rai, Lokesh SD for respondent.
Yes.
Here for the petitioner, my lord. Petitioner challenge petition, my lord. Why file the maintenance application, my lord? Trial court is awarded 3,000 rupees, my lord. Child of the
Seeking enhancement of the maintenance.
maintenance.
Yes, we'll hear it. This is a matter on 3rd of September. Yes, next.
Still number
Mala,
50.
third is third madam.
Huh?
Third madam. Apart from that, third madam.
6th. No, 1 minute.
6, 9.
10th.
Much only. Much only.
Next.
Number 52. Still number 52, B Nataraju for petitioner,
paper there, pen.
Nirmala K.
Petitioner,
Where
my
is the other side?
Chief, they are not compiled the honorable court order.
Interim order extend, yes.
We already complied, my lord.
No, my lordship. Still 4 months.
See what is complied, according to him, what is not complied.
See, as per the order, they have to
Matter.
pay 5,000 per month.
On 3rd of September, by that day, land counsel for the petitioner shall file a calculation memo before this
Their
court.
stay is there, my
And
lordship.
when he has, when and how, when, or how much amount is paid. And by that time, if there are any arrears, by, what is the date? By 3rd of if all the arrears are not cleared, the stay granted by this court stands vacated. Yes.
Still number
Into
54,
madam, my question.
Mahesh BJ.
Interim order is extended till then. Yes.
BJ
54.
Mahesh. Dinakar.
No representation, list is matter on 25th of September. Yes, next.
Still number, finally, and still number 56, Pradeep B.
Yes, Pradeep, what is it?
This case, my lord, involvement of my lord, and
His question.
my lord,
I think we will not be able to complete 327.
Reference.
So all these MFAs, 556 shall come on 4th of September. Then
57.
58,
57 adjourned, 58.
Who appears with the respondent?
I'm for the respondent in this.
Arun
You appear.
Appeal number 56, Your Lordship.
56 is all adjourned, morning. No, 56, this is adjourned to next.
Now today.
No, just
No,
now.
4-9.
We are ready for arguments, Your Lordship.
There is a reference, sir.
Ah, yes, Your Lordship.
4 o'clock.
Yes.
3:45. Serial number 58.
I appear for appellant, my lord. Claimant appeal for enhancement, my lord.
Hmm. Who appears? Arun Ponnappa.
Arun Ponnappa, my lord.
This is matter on 28th.
Matter.
Yes, 59.
59.
Short point, madam. Paid recovery and enhancement. When is that?
Tomorrow. Tomorrow.
Short point.
Huh?
Short.
Short matter, but time is not there. I have to raise by 3:30.
Tomorrow, my lord.
Tomorrow. Please.
60 adjourned, 61. Srinivasan MY. Imdes 61.
61, my lord.
What about this, Pradeep?
In this
Tomorrow?
case, my lord.
Pradeep.
Tomorrow.
Simple?
Simple. In this case, my lord, damages.
It's tomorrow.
Ayuvat.
Yes, next.
Serial number 62. Serial number 62.
I can argue the
RPFC.
matter.
Huh?
I can argue
Yeah.
the matter.
You can argue.
Now only.
Huh?
Now only.
Now you can argue.
Yeah.
Then where is the respondent?
Respondent.
It's already served. We will hear you tomorrow.
Okay.
Tomorrow.
Information, tomorrow is also after.
Tomorrow? Oh, tomorrow is. Then we'll have it. Thursday is also not. Wednesday is there, no? Whatever I said tomorrow, post those matters on Wednesday.
Obliged.
Or wherever I said tomorrow, Wednesday.
63. Wait, adu ashte.
For the respondent in this case, 63.
63. Any interim order in this?
Interim order has not been complied with. Conditional
Not
order
complied.
not complied with.
Let's
Conditional
just
order may be
matter-
passed.
This is matter Wednesday. No representation for the petitioner, counsel for the respondent is present. Then 64?
64. Ravi HK. Subramanya Prasad T.
For the petition. Okay, 1 week time.
This is matter on 11th of September at the request of the counsel petitioner. No representation for the respondent.
List number 2. Serial number 1. It is MS of 13. Vishwanatha M for appellant. Ashok N. Patil.
Respond in this case. It's a
Last time also no representation.
no representation.
New 3:30, you will give a chance till Monday.
Yes, yes.
List is on Wednesday.
Serial
No
number-
representation, in spite of the matter being listed under dismissal, still no representation. List the matter day after. Yes.
Serial number 2.
Yes, sir.
Mushtaq Ahmad. That is
Filed application for paper publication, ma'am.
No. What is this IA number 1/25 for recalling the order dated 26/6/25?
It was dismissed.
Then you have to file a petition now already. Give that.
Dismissed for not collecting the paper publication draft, my lord.
Then what to do?
I filed for a fresh application.
I number 1/25 is filed to recall the order dated. Fees, paper publication. It is already ordered IA 1/25. Why is it listed again? Subject to some cost.
Yes, I
it is
cost
ordered.
deposited, ma'am.
You paid?
Yes, ma'am.
Then why the IA is again listed? Application is filed seeking substitute notice on respondent 1 and 2 in so and so paper, and so is permitted to take out notice. Yes. Yes.
Serial number 3. 3 adjourned. Serial number 4.
I prefer second respondent.
You are saying something in the morning.
Yes, Your Lord. First
Come for
matter
the
can
appellant.
be referred to Lok Adalat, Your Lordship. Second matter, it was dismissed for non-prosecution for non-compliance of office
So I
objection.
can and what about delay?
It may be allowed subject to denial of interest, Your Lordship.
IA number 1/25 is filed to recall the order dated 6/12/2023, wherein what for that order?
Pardon, Your Lordship.
6/12/2023 order is what? Give that.
Dismissal.
For dismissal, Your Lordship, for recalling of dismissal order.
Give that. 6/12/2023. On 6/12/2023, this court has passed an order directing the applicant to comply with the office objections by 12/12/2023, or else the appeal shall stand dismissed without further reference to the court. As the same is not complied, the appeal was dismissed and the present IA is filed to condone the delay. What were you doing for 560 days? Condone the delay of 560 days in filing the recalling application. This court has perused the petition, the affidavit that's filed in support of the same. Considering the same, the delay is condoned on the condition that they will not be entitled for interest for 560 days in case they succeed in the appeal. Accordingly, no, IA number 2 of 25 is recalling the order. IA 1 of 25 is to condone the delay of 560 days. So there is, considering the fact that it's an appeal by the claimant, the delay of so and so is condoned on the condition. Consequently, IA number 2 of 25 is allowed, and the order dated 6/12/2023 is recalled. It is submitted that the matters may be referred to the Lok Adalat. Again, accordingly, both the matters are referred to the Lok Adalat. Great.
Obliged.
Serial number 58, my lord. The candidate after tomorrow, my lord. Respond counsel around Ponnappa so many times not appeared, my lord. Only enhancement of the.
So even on that day also, Mr. Ponnappa comes only, which will be enhanced. We'll see on that day.
ಇದೊಂದು ಡೇಟ್ ಗೊತ್ತಾಗಿಲ್ಲ ನನಗೆ ಯಾವ್ದು ಗೊತ್ತಾ 64 ಏನ್ ಡೇಟ್ ಕೊಟ್ಟರು ಮಧ್ಯಾಹ್ನ 17 ಸೆಪ್ಟೆಂಬರ್ ಅಂತ ಯಾವ್ದು 64 ಗೊತ್ತಾಗಿಲ್ಲ ನನಗೆ 7th ಸೆಪ್ಟೆಂಬರ್ 7/9 ನೋಡೋದು ವರ್ಕಿಂಗ್ ಡೇ ನಾನು 7th ಸಂಡೇ
17 ಹೇಳಿರ್ಬೇಕು ಮೇಡಮ್, ನನಗೇನೋ 17 ಅಂತ ಕೇಳಿದ್ರು.
17 ಥರ್ಸ್ಡೇ ಅಲ್ವಾ ಅದು ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ 17/9 ಇಲ್ಲಿ ನೋಡಪ್ಪ ಇದು 12 ಅಂತ ಇರೋದೆಲ್ಲ 13 ಅಂತ ಮಾಡ್ಕೋಬೇಕಂತೆ ಎಲ್ಲ ಮಾಡ್ಕೊ 59 13 ಆಯ್ತಾ, ಆಮೇಲೆ 61 13 ಆಮೇಲೆ
62
ಒಂದ್ ಸೆಕೆಂಡ್ ಇರು 62 12 ಅಂತಿದೆ ಅದು ಕರಂಬಯ್ಯ ನಾಳೆ ಅಂತ ಹೇಳಿದ್ರು.
ಇಲ್ಲ ಏನೇನ್ ಹೇಳಿದೀನಿ ಎಲ್ಲ ನಾಳೆ ನಾಡಿದ್ದೀವಿ.
ಆಮೇಲೆ 63 ನಾಳೆ ಅದು ನಾಡಿದ್ದು 64 17 9 65 ಇಂಚ್ ಬಿಡೋದು ಇದರಲ್ಲಿ
ನಾಡಿದ್ದು
ಇದೊಂದು ಐಎ ಒಂದು ಹೇಳಿದ್ರಲ್ಲ ಅದು ಒಂದ್ ನಿಮಿಷ ಇರೋ ಯಾವ್ದು ಹೇಳೋದು ಅದೊಂದು ಐಎ ಮೇಲೆ ಆಲ್ರೆಡಿ ಲಿಸ್ಟ್ 4 ಅಲ್ಲ ಅದಲ್ಲಲ್ಲ ಇನ್ನೊಂದು ಲಿಸ್ಟ್ 1 ಅಲ್ಲೇ ಒಂದು ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಅಂತ ಇತ್ತು ನೋಡು, ಸೀರಿಯಲ್ ನಂಬರ್ ಯಾವ್ದಪ್ಪ ಅದು ಲಿಸ್ಟ್ 1 ಅಲ್ಲಿ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಇದೆ ಅನ್ನೋದು
ಲಿಸ್ಟ್ 1 ಅಲ್ಲಿ 2
ಲಿಸ್ಟ್ 1 ಅಲ್ಲಿ
ಲಿಸ್ಟ್ 1 ಅಲ್ಲಿ 2 ಅಲ್ಲ, ಲಿಸ್ಟ್ 2 ಅಲ್ವಾ, ಲಿಸ್ಟ್ 2 ಅಲ್ಲಿ 2
ಒಂದ್ ನಿಮಿಷ ಇದು ಇದ್ರೊಳಗಡೆ ಸಬ್ಸ್ಟಿಟ್ಯೂಟೆಡ್ ಸರ್ವಿಸ್ ಇದು ಆಯ್ತು 28/8/15/9 IA 1 of 25 ರೀಕಾಲಿಂಗು ಅದೇನೋ ಇದೆ ಇದು ಅದು ಹಲೋ ಆಗಿಲ್ಲ, ಅದು ಬೇರೆ ಏನೋ ತರ ಇದೆ ಮೇಡಮ್. ಒಂದ್ ಸೆಕೆಂಡ್ ಅದು ನೋಡ್ಬಿಡ್ತೀನಿ 2863 ಅಲ್ವಾ ಇದು ಅಲ್ಲ, ಇಲ್ಲಿ ಆರ್ಡರ್ ಏನೋ ಬೇರೆ ತರ ಇದೆ ಪ್ರೀವಿಯಸ್ ಅಲ್ಲಿ IA 1 of 25 filed for recalling the order dated allowed subject to payment of cost of 1000 payable to the IA 1 ಇವಾಗ ಆರ್ಡರ್ ಆಯ್ತಲ್ವಾ ನಿಂಗೆ, recalling the order dated
26/6/25 ಅಂತ
ರೀಕಾಲ್ಡ್ ಅಂತ ಬರ್ಕೋಬೇಕು. IA 1 recalling IA
13/8
ಇನ್ನೊಂದು IA ಪುಟಪ್ ಆಗಿದೆ ಅದು ಒಂದ್ ನಿಮಿಷ ಅದು ಇಲ್ಲಿ ನೋಡು ಕನ್ಫ್ಯೂಷನ್ ಆಯ್ತು ಅದಕ್ಕೆ ಇಲ್ಲಿ ಪುಟಪ್ ಇವಾಗ ಬೆಳಗ್ಗೆ ಬಂದು ಮಾಡ್ಬಿಟ್ಟು ಹೋಗೋಳು. I have one of 2 of 25 substituted service. 2 of 25 ಕಣಪ್ಪ ಅದು ವಿಂಡೋ ಇದು ಹೊಸದಿಗಂತದಲ್ಲಿ ಸಬ್ಸ್ಟಿಟ್ಯೂಟೆಡ್ ಸರ್ವಿಸ್ ಇರೋದು IA 2 of 25 ಅದು ಕಂಪ್ಯೂಟರ್ ಎಂಟ್ರಿ ಮಾಡ್ಲಿಲ್ವಂತೆ ಅದಕ್ಕೆ
25 recalling.
ಅದೂನು ಅಲೋಡ್ ಅದು ಅಲೋ ಆಗಿಲ್ಲ ಏನಂತ ಹೇಳಿದಾರೆ ನೋಡಿ ಸಬ್ಜೆಕ್ಟ್ ಟು ಪೇಮೆಂಟ್ ಆಫ್ ಕಾಸ್ಟ್
ಪೇ ಮಾಡಿದ್ರಲ್ಲ.
ಇಲ್ಲ ನೋಡು IA1 of 25 for recalling the said order IA1 is allowed subject to payment of cost of 1000 payable to the High Court Legal Services Committee. Learned counsel is specifically directed to take substituted service within 1 week, failing which IA1 stands dismissed automatically. ಅಂದ್ರೆ ತಗೊಳ್ಳಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಆಗಿ ಹೋಗ್ತೀವಿ ಅಂತ ಇದೆ. ಈ ತರ ಇದೆ ಆಗೋದು. ಗೊತ್ತಾಯ್ತಾ ನಿಂಗೆ?
Is allowed.
ಸಬ್ಜೆಕ್ಟ್ ಟು ಪೇಮೆಂಟ್ ಆಫ್ ಕಾಸ್ಟ್.
ಅವರು ಮಾಡಿದೀವಿ ಅಂದ್ರೆ ನಮ್ಮ
ಕಾಸ್ಟ್ ಪೇ ಮಾಡೋರಂತ
ಹೇಳಿದ್ರು. I have paid ಅಂದ್ರು ಅಲ್ವಾ ಮೇಡಮ್?
ನೋಡು
India 54 and
ಹಾ ಸರಿ ಅಲ್ಲಿಗೆ ರೀಕಾಲ್ಡ್ ರೆಸ್ಟೋರ್ಡ್
25
ಅಲ್ಲ ಇದು ಯಾರ
ಇದು ಆಗಿದೆ ಬಿಡಿ ಮೇಡಮ್. Is allowed.
Counsel is specifically directed to substituted service within 1 week. Failing which IA1 stands dismissed automatically. ಅಂದ್ರೆ ಇವತ್ತು ಮಾಡ್ಲಿಲ್ಲ ಅಂದಿದ್ದಿದ್ರೆ ಸಬ್ಸ್ಟಿಟ್ಯೂಟೆಡ್ ಸರ್ವಿಸ್ ಅಪ್ಲಿಕೇಶನ್ ಇವತ್ತಿಗೆ ಡಿಸ್ಮಿಸ್ ಆಯ್ತಿತ್ತು ಅಂತ. ಅಂದ್ರೆ ಇಟ್ ಈಸ್ ಆಲ್ರೆಡಿ ಅಲೋಡ್ ಕಾಸ್ಟ್ ಪೇಡ್ ಅಲ್ವಾ ಅಂಡ್ ಸಬ್ಸ್ಟಿಟ್ಯೂಟೆಡ್ ಸರ್ವಿಸ್ ಫೈಲ್
Already ordered ಅಂತ.
ಹಾ ಅದೇನೆ ಆಲ್ರೆಡಿ ಆರ್ಡರ್ಡ್ ಅಂಡ್ ನೋ ಆರ್ಡರ್ ಈಸ್ ರಿಕ್ವೈರ್ಡ್ ಅಂತ ಏನೋ ಮಾಡಿ ಇಲ್ಲ ಅಂದ್ರೆ ತಿರ್ಗು ಬರೆಸ್ತಾರ ಅವ್ರು ಆ ಬ್ರಾಂಚ್ ಅವ್ರಿಗೆ. ಆಲ್ರೆಡಿ ಇದು ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಅಲ್ಲಿ ಅಲೋ ಆಗ್ಬಿಟ್ಟಿದೆ ಕಣ.
ನಾಡಿದ್ದು ಬೇಕಲ್ಲ ನಾಳೆ ಕೊಡ್ತೀಪ.
ಹಾ ಮೇಡಮ್.
ಈಗ ಅದು ಆರ್ಡರ್ ರೀಕಾಲ್ ಮಾಡ್ಬಿಡಿದ್ನ ಇನ್ನು ಬಿಕಾಸ್ ನೌ ದಟ್ ಕಂಡೀಷನ್ ಇಸ್ ಕಂಪ್ಲೈಡ್ ಆಯ್ತಾ.
ಯಾವ್ದ್ರ ಅಡಿಸಿದಾರ ಗೊತ್ತಾರ